Okay, we recording? All right, thank you everybody for joining us here today. Today is July 24th, 2025, and the time is 3:01 p.m. Will the clerk please take the roll call?
Yes. Commissioner Reardon,
Here.
Commissioner Murillo,
Here.
Commissioner Anaya,
Here.
Commissioner Milligan,
Here.
Commissioner Brennan.
Here.
You have a quorum.
All right, for those who wish, please stand for the invocation, the pledge, and the salute. I'd like to take a moment, everybody, for a moment of silence and to reach out to whoever you wish to help with guidance and help. Thank you. Please join us in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. I salute the flag of the state of New Mexico and the Zia symbol of perfect friendship among united cultures. Are there any objections or changes to the agenda? Hearing none, the agenda is therefore considered approved. Next, we'll do public comment. Do we have the public comment sheet? All right, so since this is going into a quasi-judicial hearing, the only public comment that will be heard is those who made public comment at the P&Z meeting previously. So I got the first one on this list then is going to be Charlene Smith. Pardon me? Oh, okay. Lisa Donol?
She's not speaking.
Okay. Chris Brown?
Thank you for hearing me today. The information I have is from the Resources for the Future and U.S. Fire Administration. Between 15 and 55% of the increase in wildfire exposure is due to population growth. Human activity causes approximately 90% of wildfires. Human activities, including land usage changes and the development of the wildland-urban interface, contribute to the increased risk and severity of wildfires. Wildland-urban interface is the area where human development, like homes and businesses, directly meets or intermingles with undeveloped wildland vegetation. It's a transition zone where the risk of wildfires and their potential impacts on structures and communities is significantly elevated. The difference between the two types of WUI are the density of housing. Housing density has a significant effect on the spread of fires, with higher density housing enabling fire to spread more easily. Many burning and highly ignitable homes overwhelm firefighters, resulting in many homes without protection. Personally, I don't want to be the next Ruidoso. In addition, as population increases, crime increases, traffic increases, water usage increases, and night sky depletion increases. Take all of those things to open areas around Edgewood rather than bringing them to our peaceful community. Most of us moved to the East Mountains because we didn't want to live in the suburbs, but in a small town environment. Please do not turn us into Rio Rancho. It's time to consider and respect your current population instead of focusing on the dollars 4,000 more homeowners will bring to Edgewood. Time to think of the people, not the money. Thank you.
Thank you. Jeff Zerzo? Caitlin Contre? And I forgot to say before for the previous, go ahead and state your name and town of residence.
It's Caitlin Cantrell. I'm an Edgewood resident and a business owner in Cedar Crest, and I also help to run farmers markets in Cedar Crest, and I'm highly involved in the community. Okay. As an Edgewood resident, I stand here today to voice our community's deep concern about this proposed subdivision. As someone who cherishes the rural heart of the East Mountains, I recognize that our way of life is not legal reason enough for you to reject this proposal. So I urge you to consider the devastating impact this project will actually have on the entire mountain as a whole, and how Edgewood and the officials who approve it will be the one everyone will blame for its downfall. As you've stated, no new testimony will be heard. So why bother with the same blatantly obvious reasons that have not proved to be enough thus far? Lack of water, infrastructure, schools, roads, fire concerns, etc. Let's simply address the process. The developers are relying on a 1999 ordinance, sidestepping the stronger 2019 regulations designed to help protect us. It has been pointed out that even within the 1999 ordinance, it states that the developers must prove infrastructure before any action is taken. Subdividing the land is action, and approving this directly conflicts with the exact same ordinance being used to attempt to pass it. So why are we all still here? I understand there's an old agreement involving saving South Mountain, but the developers have not held up their end of the agreement, so why are you risking the entire East Mountain community to please them? There might be tax revenue, but at what cost? Surrounding communities like Cedar Crest and Harris will bear the burden of increased demand without the benefits. This pits neighbor against neighbor and undermines our regional harmony. I ask the commissioners, if this were put to a vote among Edgewood's constituents, do you believe they'd approve? The silence from our neighbors at hearings speaks volumes. Their lack of support and yours
That's your
raises
time,
serious
ma'am. Can you wrap it up,
questions.
please?
Can I finish? I'm almost done.
Wrap it up.
We, the insiders who live in this reality, should have the loudest voice here, yet the lack of awareness of the situation at hand is obvious. Where is the transparency we deserve? I implore you to reject this development, protect our water, our roads, our community soul, and the future of the East Mountains. The deadline to stand up is now. Thank you so much.
Thank you. Mary Moon? Name and town of residence, please.
Mary Moon, I have an address of Edgewood, but I live just outside of town on 8 Dusty Lane.
Okay. And that microphone will bend down for you if you want.
Okay, better, thank you. I moved here 14 years ago from Illinois because I fell in love with our dark skies and the bright blue skies and the wonderful people out here, and just the whole feeling of community. And I see it being ripped apart by this increased pressure to develop. In 14 years, I've seen so many homes go up. The traffic is getting increasingly terrible. I just ask you to really consider the fact that we don't have the water in this area. Every day I see the water tankers hauling water down to Corona area. Estancia Valley Basin is empty down south. The North Valley, the North Estancia Basin is going lower. I don't see how we're going to sustain this, and I ask you to really seriously consider the future, not just a quick return or possible return. Thank you very much.
Thank you. David Thompson? David Thompson? Melissa Herbert. Laura Filler. Not sure how to pronounce this, so I'm going to try. Ardis Hager or Hagen? Hogan? All right, I'm really having a hard time with this one. Lives on 19 Southwood Drive. Okay, we'll try that. Diane Hardy. All right. Bob Sturley. Now I know that name above. That's Diane Sturley. Okay, never mind. Let's see. Stephanie or Dieger on 243 Pinion Trail. All right. Jack Faraday. Shannon Lindauer. Okay, Stephanie Lord.
Point of personal privilege, am I going to get 1 minute now, or 2 minutes now, and then 3 later as an appellant, or how is this working?
Okay, you're going to be testifying as appellant?
Yes, I am.
Then you'll save it for that.
Okay.
Joel Darrell.
Not here.
All right. Jennifer Riley. Found one, okay. Name and town of residence, please.
Jen Riley, Sandia Park. I attended the majority of the planning and zoning meeting being appealed today. I went in assuming competence of the commissioners, but very shortly into the meeting, I felt like I had entered some upside-down world. I left questioning the commissioners' qualifications and motivations. I am concerned about how community members were treated at that meeting. The first affected party speaker was rudely told she needed facts when she was citing facts. A local school teacher was publicly belittled for a moment of frustration, and a geology expert was dismissively told to find more water. Meanwhile, Campbell Ranch representatives were allowed to speak freely during the commissioners' deliberations, and on multiple occasions talked the commissioners out of adding conditions to the subdivision. The commissioners showed undue trust of a multi-million-dollar corporation while belittling its own citizens. It was a spectacle. I am grateful for this appeal process and the opportunity to be heard. Thank you.
Thank you. All right, Aunt Thornton. Vinnie Rogers on 75 Canyon Road. Okay. Mark Maynard on 144 Paco. Okay. Bill Cazone. And Scott Astrontley on 12 Oak Mound Street. Okay. All right, next on the agenda is the public hearing. Okay, so on the agenda, it states quasi-judicial hearing, appeal of the approval by Planning and Zoning Commission application for review and decision by the Town of Edgewood Commission of final approval of a plat minor subdivision. The applicant is Campbell Farming Corporation as owner, the agent CDS Sheldon Greer, P.E. The request is to divide one lot into 5 lots. All resultant properties will be subject to the conditions identified in the ordinance 1999-R. The legal description, Village 2 at the Campbell Ranch set 8, 9, 16, 17, 18, 19, 20, 21, TWP 11N, Range 6 East. All tracts are located in Edgewood, Bernalillo County, New Mexico. The properties are currently zoned master plan. The Edgewood Town Commission will hold this public quasi-judicial hearing considering an appeal of approval of the Town of Edgewood Planning and Zoning Commission of the minor subdivision. The hearing concerns the appeal of the approval granted by the Town of Edgewood Planning and Zoning Commission for a minor subdivision on May 29, 2025. Record proper pages 3,634 through 3,639. The applicant, Campbell Farming Corporation, was granted approval to create Village 2 consistent of 5 tracts on parcel 9100129931, section 36, township 10N, range 7E, located within the town of Edgewood, Bernalillo County, New Mexico. The property is zoned master plan, and the subdivision approved was granted pursuant to the Town of Edgewood Ordinance 1999-R. First and foremost, please be polite and respectful to everyone who wishes to testify and make comments tonight. I greatly appreciate that. Thank you. Before we proceed, I want to take this opportunity to remind everyone this is a quasi-judicial proceeding, given that I would like to address conflicts of interest, disclosure of any ex parte communications, and the process. First, I will address the conflicts of interest first. Matters represented to the Commission for decision may present the potential for conflicts of interest for individual officials. It is the obligation of each official to declare, for the record, any instance where a conflict of interest or the appearance of a conflict of interest might exist. Such officials must then withdraw from further deliberation, including participation in discussion and any decision-making. I would like to ask each commissioner member full disclosure of real or potential conflict interest with this item. Commissioner Naya.
I have no conflict of interest.
Commissioner Milligan.
I have a conflict of interest and will be recusing myself.
Commissioner Murillo.
No conflict of interest.
Commissioner Reardon.
No conflict of interest.
And I, too, have no conflicts of interest. All right, as it concerns the ex parte communications, when an application or other request is placed on the agenda, it becomes a matter within the jurisdiction of the commission and is subject to the protections required in the quasi-judicial proceedings and the legal restraints on ex parte communication with the commissioners. Undisclosed ex parte communication could compromise the fair and open purpose of this proceedings. If any member of the commission believes he or she has been contacted ex parte in this matter, it is his or her obligation to so inform the other members of this commission prior to the matter's consideration. And if the ex parte communication was in writing, submit it as part of the record for the meeting. Is there any member who wishes to make such disclosure at this time? Please do so now and state the name and the contacting party and when they contacted you. Commissioner Naya.
I have no conflict.
Commissioner Murillo.
To clarify, so I have received a ton of emails, but I filed them away. Do I need to email those to
Did
somebody?
you go and read through the whole email?
No.
Okay.
No ex parte, no.
All right, Commissioner Reardon.
No ex parte.
And I, too, received a bunch of emails, and the minute I saw the word Campbell Ranch, I closed the email out. All right. Are there any officials that wish to speak before we proceed? Okay. Now let's proceed with the hearing itself. And we are going to log the start time as 3:19. This appeal is governed by the Town of Edgewood's quasi-judicial procedure as set forth in the applicable ordinances and confirmed by recent commission practice. Also, a special meeting minutes, March 6, 2005. The town clerk provided hearings notice and record proper bait stamp numbers 1 through 3,832 to the affected parties in the public via town's website and correspondence. The town commission acts in a quasi-judicial capacity, reviewing the record established before the Planning and Zoning Commission. The hearing will be conducted on record, and no new evidence or testimony not previously presented to the Planning and Zoning Commission will be permitted in accordance with the town zoning ordinance 2024-017, Section 38D. The governing body shall conduct the hearing on the record, and no other evidence or testimony which was not before the commission shall be introduced. The governing body may affirm, modify, or reverse the decision of the Planning and Zoning Commission, or the governing body may return the matter for reconsideration by the Planning and Zoning Commission for one of the more findings instructions. The commission may place reasonable limitations on the conduct of the hearing, including time limits for presentations, cross-examinations, as recognized by Battersfield versus City of Albuquerque, 1989, NMCA 045-17108, NM 658. So we've already done the public comment before the hearing started, so we're good with there. All right, we will now consider with the deliberations consideration of the appeal in accordance with the quasi-judicial procedures. Procedural guidelines for the hearing. In accordance with the town's notice of hearing on ordinance 1999-R, the following procedural guidelines shall apply to the upcoming quasi-judicial hearing. The town has received timely submissions of appellant and witness lists as outlined below. The appellants, MPAC and 15 others, represented by counsel Yisil E. Enema? Is that it? Antema. All right, I was close. The third, witness designated via email to the town clerk on July 9th, 2025. All right, so that's Hessel E. Antema, the third, attorney or for argument only. Kathy Frias, Robert Pine, Sani Withers, Zach Withers, Representative Stephanie Lord, Senator Ann Thornton, Ann Thompson. Yeah. No, it should be Ann Thornton. It says Thompson here. Julie Wanlund. Forgive me if I butcher any names. Also, Mark Mold designated himself as a witness on July 9th, 2025. Bernalillo County, represented by Michael Garcia, submitted affidavits from the following witnesses: Daniel McGregor, Corbin T. Cursord. All right, the appellee, Planning and Zoning Commission, designated Brad Hill Community Development Director for the town and its witness. Given the number of appellants needed for an orderly and efficient process, the following procedures will apply. Appellate presentation. Each appellant or group of appellants, if consolidated, will have up to 45 minutes for opening statements and presentation of witness. If there are multiple appellants, time may be shared or consolidated at the commission's discretion to avoid undue delay. The commission may set a cap on total time for all appellants if necessary. Cross-examination. The appellee, Planning and Zoning, will have up to 15 minutes to cross-examine the witnesses for each appellant. If appellants consolidate their time, cross-examination may be similarly consolidated. Commission questions. The commission may ask questions for any party or witness without a set time limit, but may impose reasonable time limits to maintain efficiency. Appellee presentation. The appellee will have up to 45 minutes for opening statements and presentation of witness. Cross-examination of appellee. Each appellant or group of, if consolidated, will have up to 15 minutes to cross-examine the appellee's witness. Appellant rebuttal. Each appellant or group, if consolidated, will have up to 10 minutes for rebuttal. This time may be split or consolidated as determined by the commission. For the purpose of referencing any exhibits, please use the bait stamp number so that all parties can easily follow. So let's start with the appellant, the MPAC appellant. If there are any witnesses, please come to the podium and be sworn in.
Mr. Chair, this is Tess Eintema for the MPAC appellant. We were discussing with Michael Garcia. We're discussing with Michael Garcia.
You might have to get really close to that microphone.
Discussing with Mike.
Yep. James, can we see what's wrong with that?
Okay. Okay. Well, there we go. Okay.
Better, everybody? All right, good.
We would ask that Michael Garcia of the county, Bernalillo County, be allowed to go first on the appellant list.
All right, any objections? All right, no objections, go ahead.
Good afternoon, Mr. Chair, Commissioners. Can you hear me all right? I think I'm going to hold the microphone so it's easier to
Get
be
close.
heard. Respectfully, I'm Mike Garcia. I'm Bernalillo County's attorney. Bernalillo County respectfully disagrees with the decision of the Planning and Zoning Board. It was wrong. The reason it is wrong is it completely disregarded essential points in your ordinance and in your development agreement with Campbell Ranch. And the first part, the ordinance, is section 6D1B, and that provision says when you're contemplating a subdivision, you have to, the following matters are fundamental to consider: the availability of adequate streets, fire protection, police protection, refuse service, public schools, parks and recreation facilities, and utility services shall all be weighed in considering the subdividing of land. They are not all necessarily required. But I want to emphasize the fact that utility services is mentioned. One essential utility that you can't escape, especially in New Mexico, is water. Where that ties into your development agreement, which references the 1999 ordinance as the ordinance that shall be followed, your development agreement with Campbell Ranch is very specific. It says, Campbell shall demonstrate a sufficient supply of potable domestic water for any proposed subdivision of land at the time application is made with the town for any preliminary plat approval and in accordance with applicable ordinances and policies of the town. So at the time of preliminary plat, Campbell has to demonstrate sufficient supply of domestic potable water. You will not find that anywhere in these proceedings. You will not find that demonstration. You will not find a recognition of it in the P&Z Board's decision. It completely ignores it. That's the reason that the decision is wrong. I don't know how you can, the board in granting a subdivision can pretend like that provision doesn't exist. Bernalillo County in the past, and I'm still maintaining this today, I think that you can grant the subdivision if you put a condition on it that no development will occur without the demonstration of sufficient potable domestic water. But you have to put a condition on it. Otherwise, you're in violation of your own development agreement. And the reason this is important, this is the main point probably of every contention that we have in this particular case, is the water situation. Corbin Karsrud, the county's hydrogeological engineer, testified at P&Z back in May that parts of the Sandia Basin are seeing a depletion of up to 2 feet per year of water in the Sandia Basin. That's something that's important to know when we're talking about a roughly 1,200 acre subdivision, or what is it, 5 250 acre lots. Those are important considerations. So if you have a depletion of 2 feet per year in that area, there's obviously going to be a problem unless you can get water from somewhere else before if you're talking about what kind of a development would occur. You have to contemplate that. You have to account for that. Also, in the submission that Bernalillo County gave to you all regarding this particular case is the case of Aquifer Science, which notes that the Sandia Basin is closed to all new appropriations of water. There aren't going to be any new appropriations of water as a matter of law. It's not a question of fact unless they're going to be able to bring it from somewhere else. So it's not a fact that I'm arguing with this, it's a law. It's case law that has found what the condition of the Sandia Basin is at this point. So respectfully, and I'm going to make this short, I don't think there's really much else to talk about that hasn't already been said. But when you're looking at depletions of water, you're looking at a basin that's closed to new appropriations. You're looking at a 1,200 acre five lots out of 1,200 acres, and what could go on those. Please, please, please consider what the water situation is when you're making this decision. What the Planning and Zoning Board did is they kind of left you with something that is, to me, impossible to defend. You cannot disregard your development agreement. You cannot disregard your 1999 ordinance, which the development agreement references. So Bernalillo County respectfully asks you to do one of two things: either reverse the Planning and Zoning Board, or you yourselves place a condition on it that there will be no development without a showing of water. I stand for any questions you might have.
Mr. Chair.
Commissioner Anaya.
Mike, one of the questions that I have, and you mentioned this about one of the reports. Is that report placed in as evidence?
I believe it is. I believe it is. Do you want me to try to find it for you, or I didn't bring it with me today?
Absolutely.
Okay. Okay.
Another question that I have is, have they asked for a variance in any way?
Mr. Chair, Commissioner Nye, are you asking if the applicant has asked for a variance?
Correct. I mean, that's one thing you would know.
To my knowledge, no. They have not asked for a variance.
So if I may, that report that you're referring to is, it's page 3,659.
Can't hear.
Is this on? Can you hear me?
Okay. What page is that?
It's page 3659 in the record property.
Okay.
I thought this big pile is.
Yeah. And Mr. Karsrud informs me that it's page 5 of his affidavit that's attached to our appeal.
Mr. Garcia,
Yes.
your appeal begins with a record proper of 3646.
Okay. And my apologies, but I did not bring a copy of the whole record.
Okay, Mike. So you're saying that they cannot, according to this here, is that you cannot drill anywhere on Sandia close to this? So what you're saying is nobody can drill on Sandia Mountain area?
No, I'm not
Correct.
saying that, Mr. Chair, Commissioner Naya, I'm not saying that categorically. What I'm saying is that there's a very dire situation in the Sandia Basin, and that any development needs to be approached carefully. I'm not saying categorically there can be no drilling or no development, but it needs to be approached with a demonstration of water and approached carefully.
Which would be a condition?
I think it could be. I do. I think it could be.
Could be or should be?
Well, should be. That's probably better put. Should be.
Thank you, sir.
Any other questions?
Mr. Chair.
Commissioner Murillo.
Mr. Garcia, you were talking about the development agreement. I don't recall seeing it in the packet that I received. What page would that be on?
Pardon, Mr. Chair, Commissioner Murillo, I didn't hear your question.
You were talking about the development agreement.
Yeah.
I probably saw it in the packet if it was there. I just don't recall what page number that was.
I don't think that I had it in this particular packet. It is something that was in a separate part of the submissions. And I quoted it. I quoted it, and I can give you the citation for it, for where it is, but. To which ordinance?
If I may, Commissioner. Yeah, Commissioner, I think page stamp number page 44 on the part 1 of the packet.
And I have a copy if you need to see it.
If you have the copy, I'd like to see it.
You do?
Yes, sir.
Okay, thanks.
You have the copy?
Oh, yeah.
Yes.
Sorry, I didn't hear you.
Yes, I'd like to see that.
Okay.
Am I loud enough?
And then here's
Let me see if I can find it real quick using the search. Yes. Page 44.
Mr. Chair,
Commissioner Naya.
I have another question for Mr. Garcia.
Okay, go ahead, while everybody else is looking at 44.
Mr. Garcia, on the affidavit that you guys turned in, signed by Daniel L., there's a line on page 8 or 366, the last paragraph that says, "I am a licensed geologist in the state of Texas." Are we Texas?
Mr. Chair, Commissioner Naya, no, we're not Texas. Mr. McGregor is is Bernalillo County's, hydrogeologist. He's there to answer your question if you have anything specific.
Okay, my question then would be, is he licensed in the state of New Mexico?
Yes. Before anybody can give testimony, we need to swear him in. So, do you have any other witnesses?
No, not unless the commission wants to talk to anybody else, no.
All right, can we swear everybody in at one time, or do we have to do it separately? Yes.
Chairman, I think that it'll be a good idea to have that if anyone who's going to testify today have a sworn in at one time, you can do that, sir. And then if we have additional witness to be testified, we can have separate, sworn in testimony.
I got to think for time expediency, if everybody who's going to testify today gets sworn in at once, that'll be the fastest.
Yes.
All right. For those, every clerk, go ahead and take over the swearing in. Everybody who is going to be giving testimony, please stand.
Okay, please raise your right hand. Do you swear or affirm, under penalty of perjury, that the testimony you provide for this hearing matter is true and complete to the best of your knowledge?
I do.
Do you swear or affirm, under penalty of perjury, that the testimony you provide in this hearing is true and complete to the best of your knowledge?
All right, so that's everybody, so now we don't have to worry about tripping ourselves up. Sir, please go ahead.
So I presume it's Chair Brennan? Thank you. And Commissioners, my name is Daniel McGregor. I do work for Bernalillo County. In answer to the question, does New Mexico have professional geologic licensing? The answer is no, it does not. If you read the statement in context, it is a statement of overall professional qualifications as an expert witness testimony. Licensing in other states is one of those standards that a court would use to determine a professional standing. Last count, I believe there were 26 states in the United States that do license professional geologists. Texas is one of those. New Mexico does not have that licensing requirement. I would also add that Mr. Carsrud, the county's hydrogeologist, is also licensed in Texas as well for that same reason. And I also have a professional certification for the American Association of Professional Geologists, which I believe is also mentioned therein.
Yeah, and in your quotations here, it says "I," meaning you. have previously been qualified as an expert witness before the State of New Mexico PRC. What year was that when you did that?
I would have to go back and check records. It would have been with relation to Sandia Knolls when the New Mexico Water Surfaces Company was trying to take their water rights and apply them elsewhere. Best of my recollection, that would have been 2008, 2009, but I would have to go back and check my records as to the date on that. And again, those listing of pre-qualifications in New Mexico courts are again with regard to standing as a professional expert witness.
Okay. And the reason I'm questioning you on these is because this is your paperwork
That's
that you
correct.
submitted, and we as a jury, or excuse me, as a judge, we're not geologists. We're not judges by the meaning judge, which has legal backgrounds and everything else. So I have to go off of what I read on the documents that was provided by everybody, and the stack is like this. It's very big. We don't have the ability to read this stuff before this hearing. So I apologize if we ask questions that you all already know, but we don't. And you all want us to make a decision based on hearsay. Well, it's hearsay's fine, but it has to be in these documents too.
Chair Brennan, Commissioner, I definitely appreciate the situation. That is the reason my affidavit is as lengthy as it is, to substantiate. The substantiation of that expert witness qualification is actually in response to one of the earlier findings in this case, saying that no expert witness testimony had been provided. And that is the reason for going into that depth, is to show the depth of expertise that we have brought to the table repeatedly. And I do respect the position you're in and needing to question that, and I appreciate you doing so.
The report that you submitted, do you have the copy of the actual report that you wrote? Or did you just read one that somebody else provided?
When you're, Commissioner, which report are you referring to?
Of all the testing that was done.
So, Commissioner, that was actually a matter of public record in the district court case. That was actually prepared under my purview by a prior county hydrogeologist by the name of Sarah Chudnoff. Again, that is a matter of court record.
Okay, and he's currently employed by Burnco?
She has since left employment. We also had a subsequent hydrogeologist by the name of Philip Rust, also who provided court records with that regard. And then more recently, we have Corbin Carsrud, who is currently employed. He has reviewed those records and has also provided a summary of the current conditions in his affidavit, which was what you were requesting the reference to earlier.
Thank you, sir.
Thank you.
Chair.
Any other questions for this witness? Thank you, sir.
Thank you, Mr. Chair.
Commissioner Morrell, did you need to finish? You were in the process of trying to read and ask questions, so I wasn't sure. if you done.
No, I found it and I read it through. Thank you.
Okay.
Mr. Chair, if I may?
Yes, Mr.
If that concludes my part of the appeal, unless you have any other questions, I'll pass the microphone to Mr. Eintema.
Yeah, I was just double checking to make sure we didn't have anything. I don't think we have anything further for you. Everybody
Thank
good?
Chair, I'd like to cross-examine this witness, if that's possible.
That is possible, yes.
So, can you hear me? I want to make sure, first of all. Okay. So, thank you, Mr. Garcia. So is it true, correct, that the paragraph you reference in the Annexation Development Agreement, which is Section 3, 31H states that Campbell shall demonstrate a sufficient supply of potable domestic water for any proposed subdivision of land at the time of application is made with the town for any preliminary plat approval and is in accordance with the applicable ordinance and policies of the town.
I believe you've read it correctly.
Okay. And you also agreed that the application was for a minor subdivision, is that correct?
I do, because it's for 5 lots.
Okay, and is there a reference to preliminary plat anywhere within the minor subdivision process?
In this particular one?
In any of them? In the ordinance, in the subdivision ordinance, does it refer to a preliminary plat in the minor subdivision protocol?
To my knowledge, I don't know. I don't know that it does. I know that this is a final plat, though. And so a final plat is even more final and more binding than a preliminary plat.
But the question is, the agreement says in the preliminary plat.
Yes, that's true.
Thank you.
Any further questions for the witness?
Section 9. So is it true that Section 9 of the subdivision ordinance allows for the procedure for minor subdivision?
Let me turn there if I can.
Okay. It's on Section 9, and it's titled Procedure for Minor Subdivision.
I found it.
And it indicates that there is a 2-step process for approval as a minor subdivision.
It does.
And so there is no reference anywhere in that section regarding a preliminary plat.
No, it doesn't say that.
Thank you.
I would just emphasize again that what we're dealing with here is a final plat. And a final plat is more final than, by definition, than a preliminary plat.
So is there a definition in the agreement as to what, that a final plat is more significant than a preliminary plat? It says preliminary plat in the agreement, is it?
It does say that in the agreement, but just Webster's type.
Please keep the noise down.
Okay.
If you're just dealing with the simple meaning plain meaning of words, a final plat is far more final and established than a preliminary plat will be.
Okay, and then there is on Section 10 of the subdivision ordinance, that section is regarding what a preliminary plat is.
That's true.
And a preliminary plat does not apply to minor subdivision.
I don't know that it says that.
Well, there's nothing in the minor subdivision section that refers to preliminary plat. Preliminary plat is a protocol for subdivisions that do not qualify. Well, I don't want to testify. I'm sorry. I'm not doing that.
So the position of Bernalillo County is that you're not going to be able to dodge a requirement in your development agreement by making something that is even less of a concern or less strenuous by saying that it's a technical reason that you don't have to enforce the development agreement.
Okay, but you are acknowledging that the development agreement is relevant to this process?
Oh, yes.
Thank you.
Mm-hmm.
In the development agreement, the section that we referred to, where it says preliminary plat is capitalized, is that correct?
Beg your pardon? Could you repeat the question?
So in the section of the development agreement in 3.1H, where it identifies the reference that you mentioned regarding the sufficient water supply and their preliminary plat?
Yes.
That preliminary plat is capitalized as preliminary plat?
Yes.
So it's not just a general term, it is a specific term?
It would appear to be.
Thank you.
And again, I will restate the county's position that if something as important as demonstration of potable water is required at the preliminary plat stage, it really needs to be demonstrated at final plat.
What was that? I didn't hear. You replied to him, I couldn't hear what you said.
No, I'm sorry, I'm done, thank you.
Oh, okay. All right, sir, thank you. Sir?
Yes. Thank you, Mr. Chair and Commissioners. We agree. I represent, my name is Hess Eintema. I represent the MPAC appellants. 6 of them are here to testify. We're going to go in a little bit different order than I put in my email of notice, and I'll go through that. And I'm going to, each of them is going to have a short testimony, but it's in writing, and I'm going to ask that Junie Wanlund, who's assisting me at the table here, present copies of what that testimony is going to be to Ms. Hagar. And while she's doing that, I'm going to proceed. So, Mr. Chair and Commissioners, we agree, of course, with the county's analysis, but we have a number of other problems that I'd like to address to you fairly and briefly if I can, and I'm going to speak about them in 4 ways. There's some procedural problems with the status of how the commission is proceeding. There are significant omissions from the record, and I'm not just talking about the fact that the record was delivered outside of the deadline that the town itself set. And I think, for example, there are problems with the record, such as our appeal document is not complete in the record. A number of the submissions that we made to the county clerk, to the town clerk, are not in the record. A number of the town clerk's answers are not in the record. But let me back up and talk about the record and why it's important. And procedurally, one of the problems I have with a lawyer with this proceeding is that the town has not defined what type of a proceeding this is. Typically, you have appeal proceedings that are appeals on the record in which the governing body looks at what the commission, the lower commission did, and makes a decision makes a decision based on decision criteria, whether to affirm or grant the appeal and deny that decision. That's based on the record, and typically that does not involve new testimony. The other type of hearing, or second hearing that takes place, is a de novo, called a de novo hearing, and that's where the commission or the governing body takes testimony and makes decisions, decides its own facts, and makes its decisions. And from our perspective, your notice unfairly mixes those 2 types of hearing. And already we're into a situation where I don't know if this is a de novo hearing where you're accepting new evidence and you're going to make your own decision about whether the standards have been met for this minor plat, final plat, or if you are simply reviewing the decision of the Planning and Zoning Commission, and you're saying, we agree with the Planning and Zoning Commission decision. We've looked at the record, we've heard the arguments, we haven't heard testimony, we just heard the arguments, and we think that's the right, and they're standards. So we think, without being too legalistic, that the commission should consult with its lawyers and determine procedures for this type of a hearing, so that the parties know what's going on, and of course so that the commission makes a good record for its consideration. Let me point out on the record here, and I'm going to try to go as fast as I can. I understand there are time limits. So the record, your notice said to us that the record will be delivered at least 5 business days before this hearing. And I wrote a letter back saying that's not fair. You have to give parties more time, because with a 3,800-page record, we didn't know at that point how long it would be. We expected thousands of pages. You can't just do that overnight on the weekend. It takes time, and it takes a while to put it. And I'm not blaming Ms. Agar at all. She did as far as I can tell, a very difficult job. But the problem is fundamental with the record keeping of the town. There should be a docket that shows how things come in, and they're entered in the docket. So Ms. Agar has, it appears to me, has tried to reconstruct this record based on, way after the fact. And she just doesn't have the good information, doesn't have all the information to reconstruct the record. So the record is deficient besides being late from our perspective, and we object to that. We object to the separate agenda packet, which seems to be culling some of the some of the documents that are being presented to the commission. And in fact, I didn't object during the cross-examination, but I object here now for the record that Mr. Hill is an agent of you, the quasi-judicial decision body. He should not be an advocate. He should not be cross-examining counsel. The appellee or the applicant should be involved in this hearing, and I don't understand why the applicant isn't here, because typically you don't have the planning department director testifying in support of a decision. So the whole procedural basis of what's here today is we object, and it can be straightened out, but we don't think it can be straightened out here tonight at this point. We'd also make a couple points about your website, where we're directed to. The website has a lot of files, some of which it says are approved, and as far as we can tell are not approved. So there's, from our perspective, a lot of misinformation going on here, and culling and presentation, control of the record, and presentation of that. The record in this case does not appear to have any transcripts of any of the hearings involved. And how can we argue that the Planning Commission made a mistake if we don't have the evidence of what the Planning Commission heard and talked about? And if I get the chance, I'm going to ask Mr. Hill about that, but in terms of review, you can't review something when you don't have the record of the hearing itself. And that is a fatal problem from our perspective. There are other deficiencies. Some of the minutes of the March 6th meeting are not in the March 6th of this year. None of the transcripts of the Town Commission or the Planning Commission hearings are in this record, as far as we can tell. A number of our supplemental objections and letters are not in the record. Our appeal itself is not posted in its entirety. Pages 4 and 5 were omitted, and I have a copy here that I'd like it at least, and I notice our appeal is not, none of the appeals are even in the agenda. And I defy I don't know how to say this. How can the commission make a decision on an appeal if the commission does not have before it the appeal documents? That's what you're being asked to decide, and for whatever reason, Mr. Hill has not given you those documents. So we're definitely not on board for how this is proceeding. Some of the other, some of our initial appeal, I filed 2 sets of appeals. The first appeal, because the rules said you file within 15 days of the Planning and Zoning Commission decision. The decision came out on the 15th, but the Planning and Zoning Commission had not issued its official notice of decision. So we filed an appeal to be, just to be safe, because the town did present a press release that I put into that appeal. The press release didn't make it into your record. I can't explain why that was. It was attached, and if we get into a further discussion about it, I'll present an affidavit about what I presented to the town clerk. So we had to file without a notice of decision, and eventually a notice of decision was filed, and the other appeals came in, and we filed an amended appeal. So let me just continue very quickly. The master plan, the 2002 Campbell Ranch master plan, is not in this record as far as we can tell. Some of our arguments are that this subdivision does not comply with the master plan. We've cited the pages of that, but the master plan needs to be in the record. Your charge, as I interpret it, one of your charges is to decide, is this subdivision, minor subdivision, in conformance with that plan? And if you don't have the plan in the record, you really can't match it. You don't have the tools to make the decision. There are a couple of other pages, and let me say 5 days is, well, we got it on Friday night, and so today we're at Thursday. Normally you'd have a much better, we asked for 3 weeks to review the record because you need a correct record, and it's not, I mean, it's, in almost every appeal case that I'm involved in, there is corrections to the record or additions. It's difficult to make a 3,800-page record and get it right. And it's even more difficult if you're doing it very fast and on short time. And that's where we are, I'm sorry to say, again, in this proceeding. Enough about the record. And but let me talk about the record and the procedural problems and the issues. I'd like to take a minute and, as briefly as I can, address our issues raised in our appeal. And I mean, there are a number of them, and I just don't understand why, and I'll ask Mr. Hill, why the commission has not been given our appeal in full. And so that there's no mistake here, I'm going to ask Ms. Woodland to hand a copy of our complete appeal to the table, and it's at page 3815 if you want to look. 3815 stops at page 3 in our appeal. The base part of the appeal is 4 and 5, and some of those issues are important to us. So even if you'd wanted to spend your last week reviewing the record, you wouldn't have seen our appeal, all of it. Okay, moving through the appeal, and I'm starting at roughly at page 3813. One of the big issues in this case from our end is that the PZC applied the 1990 subdivision ordinance in error. The 2019 subdivision ordinance applies to the application. So we don't really know how the PZC got to its conclusion because we don't have the PZC's proceedings in front of us. We can't look at a transcript of what they said, who told them what they asked. It's just not possible. So we don't know. I mean, it's hard for us to argue against what the PZC did factually because we don't know what they did factually. We saw their thick decision, but there's no support for it in the record. The evidence of the hearing itself is not present. We think there's substantial law in New Mexico, and we've cited it in various times in our letters about this issue of vested rights. And our read of New Mexico law is that a developer only obtains vested rights when he or she meets two standards. First, you have to have a full approval of what you're going to do. And second, you have to have relied substantially on that approval. And so in this case, you've got an agreement back in about 2000, 20 years ago, that purports to say, or at least that's the developers and the town's argument, that this agreement supersedes any law that the town enacts in the next period of time. I mean, there's no time on it. It could be 20 years, could be 50 years, could be 100 years. That the developer is entitled to proceed under the same subdivision rules that were in place in 1999. But the problem and why the courts focus on vested rights is that in this case, the developer does not have a final approval. It has an initial approval. It doesn't have building permits or anything like that for its master plan development. That's the first part of the test. And the second part of the test is the developer has not made a substantial development project, has not built or done a lot of stuff, spending money, in reliance on it. One of the big problems in this case is that there's been 20-some years and nothing has happened. So I'm not going to go on too long. I apologize. We wrote many pages. I wrote many pages about this. I'm not sure they even got to the Planning and Zoning Commission. But we think the 1999 subdivision ordinance does not apply in this case, not only because of the reasons described by Mr. Garcia on behalf of Bernalillo County, but also under the theory of vested rights. Another major problem too, and I appreciate your patience in going through this, but this is, it's really pretty technical stuff. We think the PZC erred in approving a bulk land subdivision. This is titled a bulk land subdivision. It's not titled a minor subdivision. If you look at what it's titled, it's a bulk subdivision, and it actually kind of meets what a bulk subdivision can be or might be. But bulk subdivision is a defined term in zoning law, as I understand it. And attached to our appeal, I've put the standard for a bulk land subdivision that the city of Albuquerque has. The city of, I'm not saying that's the only way it can be done, but this is one way that a bulk land subdivision is done. So in the city of Albuquerque, you have to proceed under this section to get a bulk land subdivision, and you'll see it sets up, I believe this is at page, roughly, I don't have it exactly here, but it's like page 3829, 3828. So a bulk land is something that the town can do. It could do bulk land, but it needs to do it through an enacted ordinance that sets out the rules of what happens when a developer asks for a bulk land subdivision. And so what are some of the things that it describes how it applies, what the procedure is, and we don't have a procedure for bulk land. The ordinances, neither the 1999 nor the 2019 have a bulk land subdivision section. And I note that your attorney, I can't cite to the page right now in materials that are in the record, wrote the town saying it would be a good idea to do a bulk land ordinance. And let me just look at the last part. So 6J3, I mean, it has all of these provisions that give the government control over a bulk land subdivision. And a bulk land subdivision is generally something that the developer's putting in place, but it's not going to develop immediately. I mean, it is recognized as an intermediate step, but it's not just a minor subdivision. This provision says, and this is what the town could or might consider doing in this case, in our view, the plat shall reflect the applicant's agreement that building permits shall not be issued for any area within the bulk land subdivision before a preliminary plat and a final plat have been approved and the final plat for the subject property has been recorded. That's how one government handles this. And looking at the review and decision criteria, again, the town of Edgewood it doesn't have these criteria in place, so you're really in the dark on how to approach this type of a sophisticated development scheme. And I note that because one of the points that grabs my attention in this context is the last section of this, the decision criteria has to be satisfied, is that all lots created shall have a proportionate and reasonable share of future required infrastructure improvements. That's a pretty significant control or limitation that a government has on a bulk land. So that's our point too, that we think you can't do a bulk land subdivision without a bulk land subdivision ordinance or provision in your ordinance. It's not crazy to do that. It would be good practice to do something like that, and it would give you better control over what's going on here. Our third point, the PZC erred in not following a two-step procedure. So when the remand was done, it's a two-step procedure. The PZC just took it on the second step. For some reason, the planning department or the developer decided not to go all the way back to the first step. That's the pre-application review. We think that was a mistake. Number 4 is largely referring to the availability of water, which Mr. Garcia's talked about. One thing we're concerned about is our point 5, that this decision would create a loophole to the town subdivision regulations that would allow a continuing cycle of minor subdivisions all the way through. And that obviously would be problematic. We think that the Campbell Ranch Master Plan, pages 4 and 139, rejects piecemeal type development, which is what is on the table here today. We're also concerned, number 6, that the applicant could sell any subdivided parcel at will without any development conditions. That goes back to the problem of putting something on the plat that says, that notifies a buyer that they've got to do X, Y, and Z before they can do anything else. We think this has, in number 8, number 7 is again back to water, and although the Campbell Ranch Master Plan is not in the record, we have a copy of it, and we put it in the record in prior proceedings, and it states clearly, here's what it says. It says on page 105, note that prior to subdivision platting, the state engineer must issue a favorable opinion showing a 70-year supply of water for each subdivision. That's a pretty substantial requirement, which has not been satisfied here. There's another issue, number 8, that the plan, the master development plan, the master plan says Campbell Ranch currently controls sufficient water rights for more than half the total project. And there are other comments and why is that a problem? I mean, that's why the plan is outdated, and why the subdivision, the laws that come into effect years after the approval that doesn't have vested rights the government needs that power to protect the public. And number 9, we're talking about vested rights, a little more detail. Then our next points are relating to certain technical findings. Our point number 10 is that there's a 2005 recorded plan which establishes Village 2 as a separate parcel. There's been some argument about whether you're dividing a big parcel, but this parcel's already been subdivided. One of our letters sent in a map showing it subdivided, and that somehow didn't get into the record here. 11 is essentially along the same line of a bulk land subdivision. And some of these points are fairly technical. They're setting out what the findings are and why they're in error from our point of view. But it's really more than that. We notified them in error. You can't say what supports this because you don't have the hearing materials, what the Planning and Zoning Commission heard, what they asked, what they were told, what they said, and you just don't have the basis for reviewing their decision. We asked that the governing document, that going to number 16, there's a problem with access. 17, we think the decision does not conform with the town's comprehensive plan adopted January 7th, 2025. And that says, for example, that Campbell, on page 38, chapter 3, the Campbell Ranch is a planned community with a master plan that is in the process of being revised by the owner. Well, that's a good idea from our perspective. And the owner's certainly entitled to do that. But it doesn't seem correct to be, from our view, to be proceeding on the minor subdivision that might turn into a cascade of minor subdivisions while the plan is being revised. And we're from our perspective, that's not actually happening. The comp plan also references some water studies by Edgewood, which are significant, important for this type of decision. The last information we have says that one of the, and this is page 4 of our opinion, of our appeal, which you didn't get, the commission didn't get apparently. Apparently still in progress, there's a meeting packet, June 10th, 2025, a draft Edgewood water preliminary engineering report that are in process, and we think that the water, the people I represent think that the water situation should be studied. They're happy it is being studied, and the studies should be completed before something like this is let loose. 18 says we object to the town planning department creating a bulk land subdivision process where none exists in the ordinances. And one of our points here is about substantial evidence. Substantial evidence would be what happened at the hearing, and we can't say whether there was or wasn't. I filed the appeal saying there wasn't substantial evidence, but we didn't get a chance to review the record. The bulk land, 23, the bulk land plat is not a minor subdivision. I attached the city of Albuquerque. And again, to repeat that we think the town should establish procedures, including decision criteria, to decide this appeal. Or, if it's not really an appeal, if it's a de novo hearing, then there should procedures be established with decision criteria to make that decision. What are the rules? What does the applicant need to demonstrate? And what do the opponents need to look for? Just out of fairness. So thank you for your patience. With that, I'll go to our witnesses. We have 6. I mean, we identified them as witnesses, although as you notice, I object to witnesses in this hearing. First, in the order slightly different than my letter, which I wrote to the town on June 10th, July 9th, and that's not in the record. And also the town clerk's helpful response or thorough response, which should be in the record, is not in the record. Anyway, we're going to have Kathy Freese speak briefly, Robert, then Sonny Withers, then Zach Withers, then Robert Pine, then Representative Lord, and finally Julie Mizwanlud will close as our number 6, and I won't speak after that. And we'd point out that Mark Mull also has an appeal, and I'm sure he wants to be heard. So thank you for your patience listening to that. I'd be pleased to submit this in writing, and so that you can reflect on this, because this is a hinge decision. I mean, it may go up either side. Anybody can appeal, any of the parties can appeal it, but it is a hinge decision, and the town has an opportunity to take control of what's happening. So, Kathy Freese, next, please.
I'll remind the witness that you are still under oath.
My name is Kathy Freese. I'm an affected party, and I live at 80 Paco Drive in Sandia Park. Commissioners, my written testimony is in the public record and before you. I believe Julie handed those out. It includes references from that public record, documenting facts that are relevant to your decision today. Testimony and correspondence from affected parties, legal counsel, and more than 3,800 pages in the public record demonstrate this commission cannot defend the Planning and Zoning Commission's approval of this application. Reasons include, number 1, the Town of Edgewood actions deny due process under the 5th Amendment of the U.S. Constitution. The town's actions violate due process standards for impartial decision-making, accurate and accessible public records, and regulations with a rational basis for adoption. Number 2, approval of the application allows piecemeal development, counter to the claims of the master plan. Page 139 of the master plan conclusion says, and I quote, "It represents a radical departure from the piecemeal development currently ongoing in the East Mountains and offers a rational approach to planning for a large area under one ownership. Minor subdivision promotes piecemeal development by multiple developers on separate lots at different times, not under one ownership, and is inconsistent with the master plan conclusion." For example, a critical element of the master plan, a community-wide integrated wastewater management system with a central treatment plant, cannot be piecemealed for just 5 lots in Village 2. Number 3, the town bias supports approval of the application. The September 19, 2024 Planning and Zoning Commission packet included a memo from PZC lawyer Nan Winter to Brad Hill. After review of the application, case law, and town ordinances, she recommended amending the 2019 ordinance, which does not allow minor subdivision, to allow this minor subdivision, which could be done, in quotes, these are her quotes, and underlined by her, without attracting much attention. This would allow the town to change the 2019 ordinance to support this application. Mr. Hill claimed, based on a court-ordered settlement, that the development agreement, Section 4, supports the use of the 1999 ordinance. This court-ordered settlement has not been disclosed to the public, despite IPRA and other requests to the town. As far as we can tell, there is no document in the public record that supports the 1999 ordinance. This application fails to address substantive public and appellant concerns. The notice of decision from the May 15, 2025 remand hearing does not address substantive comments repeatedly raised by affected parties. You're being asked to approve a resubmitted application fundamentally unchanged from the original. As I said at the beginning of my testimony, this commission cannot defend approval of this application. Thank you.
Okay.
Next is Sonny Withers.
Oh, hang on, do we have any questioning of the witness?
No, but we have a question. They handed us copies, 5 copies of what they're reading. So this is actually a question for your counsel.
May I? The chair and commissioners, I believe that this hearing is based upon the record, so new evidence should be allowed. So if this is not something that they already presented at the PNG hearing, if this is new evidence, if that's the case, we should not allow.
It's my understanding you guys are just reading this, correct? This is just your report, what you're reading? Yes.
Which has been presented at the PNG hearing as well?
Yes.
This goes to the fundamental problem from our end. We think, and no, obviously the same written text was not. We'd like to think this can be considered argument, but they're being called witnesses. But counsel is pointing out that there can be no witnesses because it's an on-the-record hearing. I don't know that there's any great damage. The idea was to allow the commission to see what was being said as it was being said.
Mm-hmm.
Sir, I think right now I have to just refer to our standard of review in this town commission's hearing. It was specified in Town Zoning Ordinance 2024-17, Section 38D. The governing body shall conduct hearing on the record, and new evidence or no new evidence or testimony which was not before the PNG Commission shall be introduced. So this is standard of the review, meaning it has been the town commission will look at the substantial evidence on the record, and then which has been affirmed by the Court of Appeals in Watson versus Bernalillo County, 1991 NMCA 9, paragraph 26, sir. So I believe that unless we amend our own ordinance to standard review for the town to review the PNG's decision, so meaning that we are not entertaining new evidence, but we are reviewing the evidence before the town PNG hearing, but we will entertain the witnesses who has been testify or provide the evidence presented to the PNG so that the town commission can understand what has happened before, but not new evidence. So if this is something that has been presented at the PNG, and this is kind of summary of what has been introduced, that I believe that town commission has discretion to consider it. So I'm just saying that no new evidence before the PNG hearing. So if this is relating to the PNG hearing before, if that's the case, I think the town commission has discretion.
Well, if I may respond, your notice says on its face that there'll be witnesses and testimony and cross-examination. So that's why I've signaled them witnesses in case the commission wanted to take witnesses, witness testimony. However, these statements are largely, argument based on pages in the record. For example, we've got Zach Withers here going to testify, argue about page 2443, and also discuss what happened at the May 15th remand hearing, which is, unfortunately, we're in a bind because we don't have a record of what happened at the May 15th remand hearing. There's no transcript. Apparently the tape is not available or hasn't been indicated. So, I think they are trying to do it as argument. But it's the commission, that your notice, that caused me to designate these appellants as witnesses.
The chair and commissioners, I think, we need to hear from the P&G whether or not they're going to oppose to it, and then we can decide, sir.
Okay, 'cause it's my understanding, these are the witnesses that testified at the hearing for the P&Z.
Correct.
And they're pretty much summarizing what was testimony then, because our commission has not heard or seen that.
Yes,
Because that would have been ex parte communication, so this is the first time we're hearing it. And we also need to hear any questions of the witness, and also the commissioners need to have their opportunity to have a question for the witness. Is there an objection to that?
It's not an objection, I just think clarification. Just because the P&Z hearing does not have an official transcript, the courts and the court rules do not require an official transcript. If we were to go to district court, the P&Z hearing, which was a 7-hour hearing, and the original one was a 4-hour hearing, are still a matter of the record because it's a link you're available to watch. Instead of Mr. Entema is claiming that there's not a record of that, but there is, and it's an official record, and the official record is the actual video of the hearing, and which could be watched by this commission. So because that is what, the testimony that was received in front of the P&Z is now part of the record, that recording of the hearing is part of the record. It's just not in paper form. It is in video form. So you would have had the ability to watch the first P&Z hearing. You would have been able to watch your own hearing when you heard it for the first time. You could have watched the second P&Z hearing. Just because there's not a paper transcript does not mean that that hearing, and though the information received in those hearings is not part of the official record.
So I recommend the chair and commissioner can entertain these not new witnesses, but witness the first time before the commission, which has been presented at the town P&G hearing.
All right, so let's continue on. So do you have any questions, for this witness that was asked before?
No. Are you talking about this witness?
Yes.
No.
Okay.
Thank you.
Hang on, I got to see if the commissioner.
Sorry.
Do any of the commissioners have any questions? No. Commissioner Nye?
Not at this time.
All right, ma'am, thank you. All right, you may call your next witness.
Sandy Withers.
And I just want to remind you once again, you're still under oath.
What's that?
Just to remind you again, you're still under oath.
Yes. Good afternoon. Yes, my name is Sandy Polk Withers. My address is 50 Enchantment Lane, Sandia Park, which abuts the target area for the minor subdivision. I've testified before the Planning and Zoning Commission and the Town Commission about this topic several times in the past, so this is a short summary of my total testimony. First and foremost, all of your governing documents have similar language in them about the purpose of these documents. Amazingly enough, the stated purpose for many of them remains unchanged from 1999 to the present. For example, Ordinance 1999R, the 25-year-old subdivision ordinance that the Planning and Zoning insists governs this application, and Ordinance 2019-04, the current subdivision ordinance, say, provisions of this ordinance are designed to achieve adequate provision for light and air, public open spaces, water supply, drainage, wastewater treatment. The Campbell Ranch Master Plan ultimately calls for 4,000 new homes. This will eventually increase Edgewood's current population by roughly 130%. I know it's been argued that this is just a minor subdivision, but please realize that it is still a subdivision for the purpose of development. As the applicant testified previously in the record, page 1303, and the applicant has demonstrated no resource to support the development. It's not just water, it's schools, fire, and police stations. Whatever you can think of that the new Campbell Ranch residents will need, there is no plan for any of it. Allowing even a quote, unquote, minor subdivision to proceed ignores this lack of resources and violates the purpose of any land development per both 1999R and 2019-04, as I stated earlier. Numerous citizens and hydrologists have testified just in the last 11 months as to the unavailability of water for this subdivision, in addition to the lack of any plan to provide other resources. Given the unavailability of water supply, documented in the record numerous times by applicants, and the applicant's inability to prove a water supply, evidenced by absence from the record, the logical and responsible action is to deny any subdivision application until availability of basic resources for this development can be proven. Thank you.
Do we have any questions for this witness?
No.
Commissioners? Okay, thank you. May I call you next witness?
Next will be Zach Withers.
Sir, I'll remind you, you're still under oath.
Thank you. So my name is Zach Withers. I live at 50 Enchantment Lane. As mentioned, it's abutting the part, and specifically the part where they want to put the 800 houses on sub-quarter acre lots. We run a commercial farm there. It's a pig farm mostly. So please include my testimony in the record. Minor subdivisions are a dangerous loophole that allow development to move forward without ensuring there are adequate resources and services to support that development. In fact, in 2017, the town of Edgewood passed a 90-day moratorium against minor subdivisions, stating that minor subdivision has no basis in law. In the record on page 2443, what is especially alarming is that the town is lacking further procedures and controls that document the requirement that the applicant further has to meet before any development can take place. The City of Albuquerque Integrated Development Ordinance has clear instructions for this. It says the plat for a bulk land subdivision shall reflect the applicant's agreement the building permit shall not be issued for any area within the bulk land subdivision before a preliminary plat and final plat has been approved and final plat for the subject property has been recorded. On the record, page 3825, 3826. And so I'll slow down now. The part that I really want to get into is that at the May 15th remand hearing, the Planning and Zoning Commission displayed gross bias in applicants' favor. They deviated from the agenda that after it had been approved, moving the town staff report to the end, allowing the staff to counter all the arguments made by the appellants. Staff modified their report to address issues brought up by the appellant, which they would not have been able to do if they had not deviated from the approved agenda. Staff capriciously overreached their authority by exempting the applicant from all the requirements they were deficient on in their application, but declined to formally put those exemptions in writing. All this is available for review in the Town of Edgewood's 6.5-hour YouTube recording on the May 15th Planning and Zoning remand hearing. So those are my official comments, and I'm going to expound on this just a little bit. Without going into too much detail, coming back to the testimony from the county attorney, you guys have every legal authority to kick this back. Really simple, very clear. We have provided you more evidence than you could possibly need to throw this out. There's not sufficient infrastructure. There's not sufficient water. Both the Estancia Basin and the Sandia Subbasin are closed to new commercial applications. A 4,000 home subdivision requires an Office of the State Engineer's approval for water rights. They lost. This shirt right here, 2016, 10 years of fighting, it got kicked out. They spent $10 million trying to prove water resources, and they failed. To answer your question a little bit more clearly, Mr. Anaya, there is a exemption for individual domestic wells. So you can still drill in both the Sandia and the Estancia Basin, and if you allow a bunch of little minor subdivisions to go through, you end up with a bunch of lots with people who think that they're allowed to drill, all their individual wells. This is the major problem we're facing, and by approving a minor subdivision, and at the previous meeting, the town attorney said that they would be able to continue subdividing this down as much as they wanted. It's in the record, you said it. So I understand that the town of Edgewood was essentially founded to circumvent restrictions on development based on lack of water availability out here, but that reality of we're running out of water, you can't put a well on every 2 acres, you can't support a well on every 40 or 50 acres out here with the precipitation we're getting, and I've provided tons and tons of studies to demonstrate this. If you want to know this, I can tell you all about it if you didn't get a chance to read it. The other thing I want to point out is that from what I've been hearing here, you guys haven't read our appeal, you haven't reviewed the record, and we're here to make a decision on something when you haven't been given all the information. Just to reiterate what was already been said, it is extremely frustrating that we're facing the reality of having 800 houses on quarter-acre lots going right next door to us, no water to prove it, and the process by which that is moving forward appears to be utterly corrupt. It's extremely frustrating. So I would ask you guys, for the sake of your own town, which is dealing with its own water problems, you guys are 1,000 acre-feet over your allotted water rights. Like, sanity has to reign at some point. This is an out-of-state developer trying to put through 2 golf courses, 4 strip malls, a resort hotel in an area that is facing a serious crisis when it comes to water. And there's, I don't want to be overly dramatic about it, but 2+ feet a year drawdown in the aquifer, it's one of the worst drawdowns in the state. By comparison, eastern New Mexico, 1 foot drawdown, which is similar to the rest of the Estancia Basin, and the feds are fast-tracking hundreds of millions of dollars to try to get water to Clovis Air Force Base so that the nuclear site doesn't, run out of water. Like, these problems are real, and if you haven't looked at the information, if you haven't read the record, if you don't understand what you're doing, you should not approve this. Kick it back. You're bone solid. There's no recourse that Campbell has to sue you guys for saying that we have the right to develop this. Those rights are contingent upon them demonstrating things they've failed to demonstrate. So I would implore you to please don't send it back, just kill it. This has been going on long enough. Thank you.
All right, please, we'll refrain from that. The standing thing is great, but the clapping needs to stop. Any questions for the witness? No. Commissioners?
Mr. Chair.
Commissioner Anaya.
Sir, I have one question, a couple of questions for you. There are 2 basins that are in discussion here, the Estancia Basin and the Sandia Basin.
Sandia Basin is technically part of the Rio Grande Basin, but for management purposes, it's connected
So it's not anywhere, it's close, but it's not the Estancia Basin.
The Sandia sub-basin ends about, I think, 4 miles east of my property, which is where the Estancia Basin, it's right around Cedillo Hill,
Right,
basically.
but again, it's not, they're not intertwined.
They're geologically differentiated. From a managerial standpoint, most of the development happening and this proposed development would rely on water coming out of the Estancia Basin, which is also a closed basin.
Correct.
Closed in both the legal and the hydrological sense.
Not legally, because it's, and you mentioned this a while ago, they have the right to do individual wells. Therefore, it's not a closed, it's not.
It is closed to new applications for commercial water rights. The OSC does not recognize domestic wells as an actual water right.
We're not talking about commercial, we're talking about residential subdivision.
Large-scale residential subdivisions require commercial water right approvals. So if you want to just approve 100 little minor subdivisions and allow Campbell to sell off little lots and they can just drill domestic wells, that is in your legal, that's your legal right, I can't stop you. It is immoral. It is wrong. You're robbing future generations of a viable community.
So whether these people build or somebody else comes and builds, what would be the difference?
I mean, the point here is that we don't have water to support the existing population. So why are we approving large-scale, 4,000 home mass developments?
So
Like, that's crazy.
So if Bernalillo County came in and said, okay, let's just change the wheels here a little bit. Let's say Bernalillo County's sitting up here, and they're trying to pass this through. And they have a lot more money than what we do to expand on the process that's going in. Would all of you guys be out there doing the same thing?
I don't have a lot of fans at Bernalillo County. Bernalillo County is a good case study of what happens when you allow minor subdivisions to proliferate unchecked. There's over 7,000 lots in Bernalillo County approved for subdivision or approved for development with no water to support those, and the county is facing either they have to do something about it now after the fact, in which case they could potentially be held for takings from all the people who own property who then can't develop because they don't have water, or they have to provide municipal water, which will cost billions of dollars that they don't have, or they let all of the wells run dry, and then they get sued by all the existing residents for mismanaging their water resources, creating a crisis where we don't have access to water.
Bingo. You just said it
So
right on what my point is. Bernalillo County is doing the same thing.
It doesn't make it right.
Excuse me.
All right, please.
And I also would argue that it doesn't make it legal. Like you guys right now, because we've submitted all the evidence, you can be held accountable for making a decision to move this development forward in a way that I hope someday Bernalillo County will be held accountable for.
Well, do you see our point up here is?
I understand you guys are in a tough spot.
We have to ask all these questions and try to get the best information that we can out of both sides, not just one side, but both sides. And you hit it right on the nail. You told me that. You just said it. Bernalillo County has problems over there too, but
So does
they
Torrance
still
County,
get
so
it.
does Sandoval County, so does Santa Fe County, so does the whole damn state, excuse my language. I mean, I also submitted all of the recent legislation that has been passed that mandates things like a 40-year water plan. I mean, you guys don't have a 40-year water plan for the existing residents of the town proper. EPCOR is not going to service this. I spoke to their director, who I've known for 25 years, and he said, outside the service area, not even an option. Right, so you're contracted, the town of Edgewood is contracted and should have had you guys did your water ordinance, water utility ordinance, which you were supposed to do when you founded the town as one of the 5 required utility provisions. That utility that you contracted with to check that box isn't going to cover this part of Edgewood.
And that's why we're not talking about the town of Edgewood supplying water to this subdivision.
But you
It's
are-
their problem, not ours.
Technically speaking, you're legally required to provide 5 out of the 9 essential services, and Edgewood opted to claim water as one of those essential services and contracted with
No,
a
we did not.
Canadian-owned company
Did
to
not.
provide water to the people of the town of Edgewood, who are not going to provide water to this part of Edgewood.
That's a false statement.
To the best of my knowledge, that's correct. I don't know
Okay,
everything.
Now that you said that, to the best of my ability, best of my knowledge, that fits.
Yeah. I don't,
But to say that we are going to, that's false. We're not going to do that.
I would see approving a subdivision application as an endorsement of development. And like, if you guys aren't aware, Campbell's going broke and they're trying to leverage part of the property so that they can raise money. Objection sustained, I shouldn't have said that.
Yeah, that was-
We're now in the, we've got
Campbell has-
the original record. We
Campbell
took
has-
the original, away from the original record, and we're
All right.
getting into new arguments that are being raised, and speculation, and
I will refer to the record. The applicant has stated that their intention with this minor subdivision is to be able to put up a piece of the property as collateral against taking a loan. That was stated on the record multiple times. And
You have to point to the record.
well, I mean, if you had the record, as we've discussed extensively,
Well, you do have the record, I have watched.
I was at the meeting, I heard it.
I watched the 4-hour meeting, even though I didn't attend it, more than 4 times to make sure that I understood what was going on and I got the record straight. I also attended the 7-hour hearing, I was here the whole time, and.
As was I.
And I appreciate your support, but you would have to point to the record,
All right.
minute or time, what that said, because that, I don't remember that.
In the opening comments at the P&Z meeting, the representative for Mr. Gately, acting on behalf of Campbell Corporation, represented to the Planning and Zoning Council that the intention behind this division was so that they would be able to leverage a piece of the property without having to put the entire ranch up as collateral in order to raise funds to try to do something. Presumably, possibly pursue the development. It wasn't entirely clear. What I bring that up to say is that one potential possibility here that I brought up at the last meeting, and I want you guys to be aware of, is that if Campbell goes and leverages a piece of this property by representing that it is eligible for this development, that creates, this sort of, it creates a problem where you start to become potentially complicit in them making claims that they can't substantiate based on lack of water resources, lack of fire, lack of police protection, all of the reasons that make this development essentially a pipe dream. That comes back to bite the town. So I would advise you to think carefully about the potential legal ramifications for the town in pushing through a minor subdivision to support a 4,000 home development. It just makes no sense.
Counsel, that's also on page 2581?
2815.
2815.
I'll go back.
Thank you.
2581.
2581. That's what I said the first time.
Yes, sir.
Trying to make me feel like
I'm
I'm
sorry,
seeing it.
258?
2581.
It looks like it was a transcript.
Are there any other questions for this witness?
No, I'm done.
All right, sir, thank you.
Can I make a recommendation before I sit down?
No.
Not really. That would be outside the purview of your testimony.
Is this being governed by Robert's rules?
This is a hearing.
Are there rules on how the hearing is held? Generally, Robert's rules is the default.
Not for the,
If I may, I believe that this is not Robert's rule. This is quasi-judicial hearing, and then we refer to the New Mexico Rules of Evidence and then other civil procedure as a guidance, and also not necessary to follow all of them, but we have some leniency there. Yeah.
Gotcha.
all right, sir, you may call your next witness.
Next is Robert Pine.
I'll remind the witness you are still under oath.
Members of the commission, my name is Robert Pine. I have lived in Sandia Knolls in the Sandia Basin for 32 years. I am a groundwater hydrologist who worked for the state of New Mexico for 28 years, including 8 years for the Office of the State Engineer. I now work part-time consulting, and I do work for the State Engineer and for the New Mexico Bureau of Geology. Please include this in your record of today's hearing. So there's been a lot of discussion about water, and that's what I'm going to talk about because that's what I do. Water to supply Campbell Ranch will have to come from either, as you've already heard, the Sandia Basin, the Estancia Basin, or the Rio Grande Basin. There are no other options, okay? And all three of those basins are closed to new appropriations. The reason Sandia Basin and the Estancia Basin are closed is because they both have regionally declining groundwater levels and cannot support additional withdrawals. In fact, these basins cannot even support the current amount of groundwater withdrawal, thus the declining groundwater levels. In the Sandia Basin, there is also, unlike the Estancia Basin, no large-scale irrigated agriculture. You'll find no center pivots in the Sandia Basin. So the declining water level in the Sandia Basin is due to just domestic withdrawals and declining recharge of the aquifer, which is a statewide problem. It's useful to look at the Clovis-Portales area to our east. The eastern part of the state was mentioned by Mr. Withers. And this area, like the East Mountains, has no surface water, so all water use is fully dependent on groundwater. Intensive irrigated agriculture began in that area in the 1940s, and it was clear from the late 40s, early 1950s that groundwater levels were dropping at 1 to 2 feet per year, and the aquifer in that area at that rate would eventually be depleted. Rather than curtail groundwater pumping, in the late 1950s, the communities and the state constructed the Ute Reservoir on the Canadian River some 60 miles to the north of Clovis. And that was intended to be the future water supply for the Clovis-Portales area. Meanwhile, irrigators in that area continued to pump like drunken sailors. By the early 2000s, it was apparent that the communities were running out of water and started planning and fundraising for the project to treat, pump, and distribute the water at an estimated cost at that time of $500 million, taxpayer dollars. More than 20 years later, the project is only partially funded and partially constructed, and the price tag now is going to exceed $1 billion. More than 20 years later, So the question that all this poses was this smart water management. And of course, that's very debatable. Though they have an alternative water supply, it came at great cost to taxpayers and in fact may not even prove to be reliable in light of current climate conditions. And ironically, irrigated agriculture is going away very soon because there isn't the water to support it. So all this came about to sustain irrigated agriculture, and in the end, there will be none. So, members of the commission, I ask you, where is Edgewood going to get water from when your wells go dry? Where will the citizens of the Sandia Basin get their water from? It won't be coming from Albuquerque, and it won't be coming from anywhere. $1 billion won't buy the East Mountains a new water supply because there is no alternative source of water. I mean, even if there were, how would you distribute it? The people in the East Mountains are dispersed over hundreds of square miles. It's basically an engineering impossibility. So, without sensible water management now, the East Mountains will go the way of Schwabach Farms. And I think you all know what happened with Schwabach Farms. So to approve Campbell Ranch without a proven water supply that does not threaten the very existence of the residents of the East Mountains is pure folly. Water supply should be the paramount consideration of this commission from the very beginning of the process. That's my testimony I submitted. I'd like to just mention, in light of the previous discussion, that domestic wells, as individual domestic wells or shared domestic wells, as a possible path to water supply for Campbell Ranch, will doom the Sandia Basin. Because it doesn't matter if you have one big well pumping, 1,000 acre feet, or 1,000 wells pumping the equivalent amount of water. It doesn't matter, okay? So I would urge this commission to not allow that kind of development. And in fact, the state engineer, I'm not sure they would allow it either. There's a big difference between, Joe Blow with a lot wanting a domestic well and a 4,000 lot development wanting to put in individual domestic wells, okay? That's something that should never happen. Okay, thank you. I'll take any questions.
All right. Any questions for the commissioners? Any questions? Is that a maybe
Look at
thinking?
them
or-
saying, look at them saying, no, get it. No, I don't, thank you.
All right, thank you, sir. May I call you next witness?
Next witness is Representative Stephanie Lord.
Oh, I should recuse.
Representative Lord, I'll remind you, you're still under oath.
Absolutely, Mr. Chair. I'm under oath all the time because I get sworn into office. So I am here today because we have a big problem. I'm not here as a representative, I'm here as a neighbor. I'm here as a person who lives 7/10 of a mile away from where where they're going to start building homes. I moved here for this beautiful community. I moved here for the environment. I moved here not because I want a mega development built down the street. The town of Edgewood Planning and Zoning is ready to allow this applicant to move forward with developing property according to a 20-year-old urban sprawl plan, which no longer reflects conditions, which I would actually say there was already a ruling on that, where they said, I think it was in the Spring Port, that said you can't have something that was agreed upon years ago and it just be okay forever. So I'm going to talk about the water like everybody else has, and I talked to these wonderful two gentlemen right here. Thank you for all your wealth of information to find about how our little area up there goes down an inch each year. And our lives depend on water, and like many others, I faced a dry well. And I live 7/10 of a mile away from where you're about to build, and my well went dry. I, as a representative, get to hear about all the people who their wells have run dry. There is a community, I just went to their meeting, and it was horrific. They've been 2 months without water, and it's right out there. Melody Ranch is what it's called. It's right between Edgewood and Moriarty, and they have no water. None. They're having the water shipped in from Albuquerque, and how long can they keep going? Their houses are worth nothing now. The fire department can't use the well, can't use anything other than bringing their own water if there's a fire. I get really irritated at this, that I have to keep coming back on this, because these people here have presented amazing evidence of why this should not move forward, and I feel like I'm just being redundant. Schwabach Farms, they no longer have water. This community right down the street from you no longer has water. Estancia, their well went dry. So what happens to us, all the people that are here, when these wells get put up and the well runs dry and none of us have any water? What happens when Edgewood doesn't have any water? This is one of the main issues and is extremely serious because we can't keep going. Our house values will become zero. We can't all get water shipped in. It's not going to work. Because this is the issue they're having in Melody Ranch. After a while, it's that supply from Bernalillo County is going to end. So it all keeps boiling back to water. We've talked about the traffic. So you're going to bring in thousands of more cars, speeders, and crashes. And so who's going to pay to widen lanes? Who's going to police that? Have you guys talked to State Police Officer Wexler? Have you talked to Bernalillo County Sheriff John Allen? He's dead set against this. We don't have the resources. So watch how this is going to play out. More people, more speeders, and all of you who know 14, there's a ton of speeders and there's a ton of crashes that happen on there. So now there's nobody policing it. So that makes more speeders, more traffic. It ends up with more people coming up to do crimes up in our area because there's not enough people to police. So not only do you not have a 40-year plan for the water, Sheriff John Allen has said that he's not on board with this. So you have, because now you're in Bernalillo County. You're no longer in Santa Fe County, you're in Bernalillo County. And let's talk about the schools. So where's the funding? Are you guys going to build schools out there? That's my question to you.
Are you going to build schools? Or do we, who live in Bernalillo County, have to pay for this? And why is that fair that we would have to pay and put out more money to APS? How is that fair? So I would hope that if you're dead set on moving forward with this, you have a couple things you have to do. You have to figure out how to supply Bernalillo County Sheriff's Department with more money and more policing. That's right off the bat. You're going to have to help the state police out there. You're going to have to help with DOT that's going to have to maintain those roads as more people, more aware on the roads. With the schools, you can't expect us to have to foot that bill. And now let's talk about law enforcement. I already said Sheriff John Allen is not on board with this. So Edgewood Police Department, your own police department, who I'm going to work with because they need a police department, an actual real police department. Are you now going to put are you going to put a police department here for like what, 5 or 6 million and then build another one out there? They can't get out there in time to police that. That's not fair for you guys to put an area with a bunch of homes in there in our area, in our backyard, and have no way to police it. That's not fair to us at all. Are you going to put a fire department out there? How are you guys going to pay for all this, or are you just putting the bill on us? Because that's what it seems like what is happening right now. We're going to move forward with this. I'm not saying you guys, because I know all you guys, and I know your heart, and I know that you aren't thinking you don't care. I'm not saying that in any way, shape, or form. What I'm saying is I'm very irritated with who's going to pay this. Can you guys show me where you have the money to build a $6 million Edgewood Police Department out there? And where are you going to hire the people to work there and pay their staff and pay their para, all that stuff that goes along with it? Who's paying that? How is that happening? The other frustrating part is I'm very worried about fire. We have the mountains out there. I have written to the Forest Service and begged them to please come out and thin out that forest. Also for the recharging of water, and that's because it's dangerous. So if there's a mass exit, we already have a hard enough time just trying to get people out of there. Are you guys going to supply us with a fire team to fight the fire? Are you going to help us get the people out of that area? Because it's a very hard area to get in and out of. So I get very emotional about this because you're screwing with our backyard. You guys have claimed Edgewood as yours, and to us it's not. And then when they send out that mailer saying that we're outsiders, how dare they? They're the outsiders. That's not Edgewood. That is Sandia Park and that is Bernalillo County, and it's very frustrating that we have to come here to testify to tell you that that's our backyard and there's no water. So I'm going to put this on record. When all of our wells go dry, are you guys going to pay for it? Are you going to pay for the water to be hauled into my backyard? You guys know me. My well's already gone dry. Are you going to pay to put the water into my house, into my system, so I can live there? The water keeps going down. The levels keep going down. You guys, nobody has proven to me that there's a 40-year plan. Actually, what I'm hearing is quite the opposite from the experts, is there's just not enough water. But I could tie it back to, you're going to have to help John Allen and the Sheriff's Department. You're going to have to put a ton of police out there. You're going to have to build a station. You have to build a fire. Also, I talked to the postmaster, and they said they cannot handle any more people, so you need to get the federal government to put a post office out there. This isn't just we're just building some houses and putting some wells. This affects every single person here. And it's going to come back to, can you guys afford this? Can you guys afford a school and a police department and everything else that goes along with the infrastructure? Because it's not just putting some houses. And I wouldn't care if it was Bernalillo County or who wanted to put it in. The fact of the matter is, it's not just even, it's not ethical, it's not moral, but you can't do it because you guys don't have the money and the resources to make sure that I don't have to worry about more speeders, more traffic. I don't have to worry about my well going dry, because that's not fair to anybody. That's not for any of us. So what I'm asking you for is just kick this back. It's pretty simple to me. Unless you guys can show me that you have all these things to support this infrastructure from the city of Edgewood, There's no way you can make this happen. And by the way, the developer does not have the right, as far as I can tell, to build a police station and man the staff for that or any of that. So it falls on the city of Edgewood. So my thing as a legislator, I'm here as everybody's neighbor to make this more emotional so that you understand, you guys have to look me in the eye if my well goes dry. You guys have to look these people in the eye if suddenly there's more accidents, somebody ends up dead. You guys have to look us in the eye if we get a huge increase of crime. So it's more than just building this building, it's the effect that it has on every single person here that I'm representing. I can't make it any more personal than that. So with that, I stand for any questions.
Have any questions?
None, thank you.
Commissioners, any questions?
Mr. Chair.
Somebody spoke, I don't know who.
Thank you.
Okay. Commissioner Reardon.
Ma'am, do you have an idea how many wells have gone dry in that area?
Hold on while I defer to my experts. Do you guys have any idea of how many wells have gone dry? You monitor the wells. According to my experts, up to 20%.
Thank you.
Anything else? No?
Anybody else?
Mr. Chair.
Kick this can down the road, you guys. I don't want to have to look you in the eye when my well goes dry. Thank you.
Mr. Chair.
Commissioner Naya.
Madam Rep, I have questions.
You could have been a little quicker on that one.
Yes, sir. Representative Lohr still here.
Okay, and this has been brought up earlier today too, is that when the town became a town, a pipe dream, as it was back then too, in 1999, I can recall a lot of people saying, it's impossible. Well, nothing's impossible if people want to do it, okay?
Commissioner, what are you asking? Is that a question, or are you
No,
making a
it's not
statement,
yet.
or what is your?
It's not yet.
Okay,
I'm
just,
talking
wasn't sure.
to you the way that you talk to other people too, okay?
Okay.
So
I
I'm
see.
trying to get to your level. Excuse me for if I'm not reaching you yet.
No, you're fine, Commissioner. I just didn't know if there was a question in that.
No, I would have put it.
Question at the end. Okay, got it.
I know you and I never get along. I mean, this is apparently, has been going on for a long time.
Yeah, and that's
But
fine.
this is not personal.
But I will also say that Zach Withers right here ran against me, DTS, I get along with him just fine, and there's Augustine Montoya, who's a Democrat, who I get along great with. We're great friends, so.
I know.
I judge people by who they are, not by what political party they are, but I just wanted to be clear about that.
Good, I'm glad. That's the way I like it to be.
Can we get to the question?
The question is, shit, now I forgot.
I can.
So you did your job right.
You were saying, Commissioner, that nothing is impossible.
No, what I was saying is, this town started in 1999. 2001 is when Campbell came and asked to be part of the town of Edgewood. I don't think any of us were sitting up here at that time. I know for a fact that I was sitting out there with you guys when they came. Back then, I thought, you know, it could be a good thing back then in 2001. 26 years later, I don't know. I don't know. Because there's so many variables that are not certain yet.
Point of order.
Who called the point of order?
What's the point of order?
Mr. Chair, this is to be asking questions of the witness. There's no questions, it's just a history.
No, please, get to the question.
Now you know what it's like to be a rep. Same thing happens when you're sitting up there and you're representative. You can't talk, you have to get to the questions.
I've been involved in this politics for a long
Let's
time, I
just get to
understand.
the question.
I admire all the people out here that are here to fight for what
Point
they
of order.
believe. Let me finish. I'll tell you what, I'll pass.
Okay, if you had a question, I would have gladly answered it, but I hope, as my final statement, that you guys look at evidence, and that we've brought forward a lot of evidence. Thank you.
Now, Representative, I do have one question.
Sure.
Has the state made any mention or had any interest of purchasing that property that turned into state land?
Actually, there has been some discussions about that, and I would love for that to be turned. I know that there is a fund that actually can go out and buy land, and if anybody has Ted Turner's phone number, that would be a great place for him to put some buffalo out there. And there is some discussion, but I haven't heard anything solidified. I would love for that to happen, for them to get the fair price that they want, and then be able to have that land held and use it for more things, like a cultural center too. Actually, I would love to see it where the original indigenous people and the land grants that lived there were honored, and there was a community center for both of those, and mountain biking and horseback riding and stuff like that would be great.
And then going along with that, if the state did wish to purchase that land up there, would they want to purchase the whole thing, or they want to purchase just a chunk of it?
I don't have an answer for that.
If they were to purchase a chunk of it, then it would have to be subdivided.
I have no answer. I'm no expert on that.
Okay, thank you.
But Ted Turner, if you're out there.
Mr. Chair, can we do a 10-minute recess?
That would probably be a good idea, because I've been watching some people, and there are some wigglings going on, so we'll take it. We'll take a 10-minute recess. We'll be back here at 5:30. All right, hopefully everybody's back and taking care of what they need to take care of, and we have the next witness lined up. Once again, I remind you that you're still under oath.
Yes, sir. All right, thank you. My name's Julie Wanland. This afternoon, we've heard from several individual MPAC appellants about procedural errors in the application and the May 15th hearing, as well as about real threats to individual neighboring property owners from allowing a subdivision to take place without proper procedures and controls in place. So MPAC previously appealed the original November 2024 P&Z approval to the Commission, and at that March 2025 appeal hearing, you recognized many deficiencies and errors and voted unanimously to reverse the P&Z November 2024 approval and remand the application back to the Planning and Zoning Commission for further proceedings and reconsideration to include a new hearing of the application. So my first point, and Mr. Eintema made this point earlier, that new hearing did not properly include the application from the beginning of the two-step minor subdivision process. And then, in addition, as noted in the Burnco appeal, many concerns that they expressed in the March 2025 Town Commission hearing were not addressed in the Planning and Zoning remand hearing. And I would also ask you, the minutes from the March hearing were fairly extensive, 6 pages long and very detailed. And I'm not asking you the question, but I'm just posing the question for thought. Were the deficiencies that you noted in those minutes sufficiently addressed in the remand hearing? And one more thing about water, because we haven't heard enough about that quite yet. So we've had hours of testimony from hydrologists and citizens about unavailability of water and have submitted literally hundreds of pages of technical data in support of our statements. We've been asked several times to provide proof, and frankly, it's insulting at this point. One of our MPAC appellants, Zach Withers, submitted a document that's in the record, pages 776, 777, that lists 13 links with technical information regarding the water situation in New Mexico, all from credited sources like the OSE, New Mexico state laws, U.S. Geological Services, and the Bureau of Geology. We believe we've made effective arguments for the reversal of the minor subdivision approval, but if you choose not to do that, please consider that you have another option to address the community's concerns about development taking place without resources. Just like the city of Albuquerque, you could require that the P&Z place conditions on the minor subdivision final plat, that no building permits will be issued before a preliminary plat and final plat have been approved and the final plat recorded. In the P&Z notice of decision from May, it says several times that no development can take place as a result of this minor subdivision. So why not include that provision directly on the minor subdivision final plat for all to see? Thank you.
Okay. Questions for the witness?
Mr. Chair.
Oh, let's let P&Z first have Dave.
Okay.
I know. Can you give me just a minute? No questions.
Okay. Commissioner Naya.
Can you state that last must do?
Must do. With the sentence that starts, but if you choose not to do that?
No, the
No?
part where you said that.
Okay. So in the P&Z notice of decision?
Yes.
From the May 15th remand hearing, it says several times that no development can take place as a result of this minor subdivision. So my question or challenge is, why not include that statement directly on the minor subdivision final plat for all to see? And the model for that is the City of Albuquerque document that is in the record showing how they approach that with that exact language that goes on what they call a bulk land subdivision plat.
Thank you.
Any further questions?
No.
Any questions? No. Thank you, ma'am. May I call you next witness?
We're done.
You're done. All right. All right, does P and Z have any questions for MPAC?
Mr. Heinlein, is it true that regarding your objection regarding the second pre-application hearing, the first appeal decision by this commission did not require a second pre-application hearing? Turn your mic on, Brad. I'm sorry.
Well, did you want me to restate that? Okay. So is it true that the, regarding your objection about the lack of a second pre-application hearing, the first appeal decision by this commission did not require a second pre-application hearing?
First, Mr. Chair, I object to being cross-examined. I'm here as counsel. I have no personal knowledge about the case, and I'm not in the business of, I don't testify as a lawyer.
Okay.
And you're asking me a leading question.
It's a question about the record, but I apologize if we're questioning you about the record is a leading question.
The record is what the record is. I don't have
Okay.
an answer for your questions about the record.
So you testified for your clients, but you're saying, so you're saying, I'm just trying to understand, so you're testifying for your clients, but you're not in the ability to be crossed regarding your testimony?
I'm not testifying for my clients. I presented argument. I explicitly stated in my notice that I would be presenting argument. I didn't attend the lower hearing, and I'm not a witness.
Thank you.
So I do have a question then, because I have questions that would be referred to MPAC that I would like to have answers to, and you're representing MPAC, so you're the only one we have here to ask the question to.
To the extent it's a question about the argument or about, well, it's a difficult situation. I mean, we've presented this as though it's a trial setting with witnesses giving testimony. And I'm not a witness. I'm a lawyer for clients. And, I mean, from my perspective, if they had questions of the people providing testimony, they were asked during the period.
Counselor, yes.
Can you, okay. So I think at this time, sir, this is quasi-judicial hearing, so the quasi-judicial, the commission as a judicial officer, they can ask you as a representative and counsel as some question about the argument you made, sir, right?
Yes, I agree with that.
Yeah.
But I don't think it's cross-examination.
No, I think commission as a judiciary, quasi-judicial capacity, they have question for you as a representative and counsel for the impact. Is that okay?
Yes, and I'm not resisting that. I'm resisting being cross-examined about testimony.
I think, sir, the commission can have a question for the council representing MPAC, based upon, his argument present to the commission.
Okay. So are there any questions from the commission? I've got a list. I'll wait till everybody's done.
Why don't you go ahead and then we'll bounce off of it.
All right. My first question is, sir, this is for MPAC. What is your legal basis for asserting that the 1999 subdivision ordinance should not apply to the subdivision despite the 2001 development agreement?
Under the New Mexico case law, that follows vested rights, a government retains the ability to enact ordinances that will affect pending development unless the developer or owner has established vested rights. And the vested rights test has two prongs. First, to have a vested right, the developer has to have a final approval, like a building permit, and the developer has to have put substantial reliance, probably starting the building, something like that. And the cases are in different directions on that, on what actually has to happen. But our perspective, our position is that the developer in this case has not established vested rights under New Mexico law, so that the developer is subject to intervening enactments, intervening legislation. One of the leading cases that I cited in the materials I delivered is a case called Mandel in Santa Fe. Mandel wanted to build a project, and he had an approval for a certain height. And then while that was pending, the city council or the intermediate body changed the rules about the height that he could build to. And the court said, and I'm paraphrasing and summarizing, the court said, Mr. Mandel, you lose because the government retains the right to change the laws, and you are protected from those changes in laws if you have established vested rights. And Mandel had not established vested rights because he didn't have a final permit for his project, and he had not expended funds to complete the project. So our argument is based on the application of New Mexico law to the circumstances of this case.
Anybody want to add on to that? I just don't want to keep on going and if anybody else has something else.
Yeah, no,
Okay.
I'll let you know.
All right, so the next one is, do you contend that the 2001 agreement is no longer valid or has been suspended by the 2019 ordinance by state law, or state law, excuse me?
No, but to the extent that the 2019 ordinance changes the development rules, our interpretation is that if the developer does not have vested rights, he can't proceed under the 99 ordinance. So the development agreement still works on a variety of fronts, but it doesn't give the developer permanent protection against changes in the law. And I think if you take a moment and think about that, suppose the state of New Mexico, or suppose the town were to say, we can't approve anything because there's no water. Would the town really be allowed, would the developer really be protected from an agreement made tens of years ago for a circumstance, for legal changes in legal ordinances concerning matters that have come up in the period of time that the developer has not acted? So the government, the law gives government power to protect people, and that power, the government can't just give it away. Or if the government does give it away, the person who's gotten that agreement only is protected if he has established or he or she has established vested rights. I'll explain, and I'm not. It's a topic of argument. There's no. I mean, I've had a case with Mr. Garcia on the other side concerning vested rights.
Okay, my next question here then is, if the town has consistently applied the 1999 ordinance to Campbell Ranch subdivisions, what precedent supports a change in that practice now?
Because the town determined in 2019 that the way subdivisions should be done in the town of Edgewood is in the 2019 ordinance. That the town undertook and examined the subdivision situation and said, you know, we need to change how this works, and here's our change. And our view is that the developer has to comply with that unless the developer has established vested rights in the prior approval.
Well, thank you, sir. Do you agree that the bulk land subdivision does not confer development rights?
That depends on what you mean and how it's worded and why it's, how it's documented. So bulk land subdivision by itself is kind of this amorphous thing that people think about differently. Different people can have different thoughts about what bulk land subdivision means. In the context here, you don't have a definition that defines a bulk land ordinance or authorizes a bulk land subdivision. So, to get to your question, it's yes and no. I mean, if we were operating under a jurisdiction that had a bulk land subdivision provision, we would look to that and say, here's what you have to do, A, B, C, and D, and here's what you get. And in the city of Albuquerque, which has a bulk land provision, it says that this does not give development rights. And so they put that on the plat. But my read of the situation here, and I'm an advocate for the opponents, is that there's no authority in this body to approve a bulk land subdivision because you don't have a bulk land subdivision definition or ordinance.
Okay. What specific infrastructure or procedural steps do you believe must be completed before development rights can vest for the tracts created by the subdivision?
Development rights, and that's a complicated fact question that I'm not able to answer other than kind of broadly. And the cases are in have different divisions or different reads on how much the developer has to do to establish vested rights. It's the court law, my recollection says that that's determined on a case-by-case basis. I think on one hand, if a developer has actually constructed its building in reliance on a building permit, the new law that came into effect while that was being built doesn't apply because the developer has the approval and has relied on that approval. But that's not the circumstance here. The final approval for development of this has not been granted or obtained, nor has the developer, to my knowledge, spent a lot of money or spent any significant money realizing that approved building permit, for example. I don't know if that is responsive to your question, but trying to put it in context. And so what level of infrastructure would have to be put in or other factors, a court would look at that on a case-by-case basis. The court has said in one case that I've cited recently in a brief is that just owning the land or just buying the land is not enough to establish reliance on a development approval.
Okay. Thank you on that. Two more questions for you. If the subdivision is approved, what conditions do you believe are necessary to ensure that future development complies with the current standards?
Well, that's a tough question because I'm an advocate that this should be rethought, and you need it in the context of a full plan. But if, as Ms. Woodland argued, putting on the plat the rules and the standards that apply for development on this non-development plat is a good start. But I'm not sure the commission has authority to do that because it doesn't have an ordinance that says this is what we can put on the plat. The city of Albuquerque has this other stuff too that they put on the plat. I mean, or they can put on the plat. This is, I think I'm looking about page 3820 or 3822. I don't have the quite page. The language that the plat shall reflect the applicant's agreement that building permit shall not be issued to any area within the bulk land subdivision before preliminary plat and final plat have been approved and the final plat for the subject property has been recorded. So in the city of Albuquerque operating under that ordinance, a bulk land plat is really preliminary to a preliminary plat. It's kind of a mechanism to start thinking about a plat. The other thing that the city of Albuquerque puts on it, and I just suggested this as a model because there's no written law out there for bulk land subdivision that I'm aware of. It says all lots created shall have a proportionate and reasonable share of future required infrastructure improvements. That might be a pretty hard pill to swallow for a developer, depending on the circumstances. I don't know. But so this is a complicated question. It's not something where I think the commission would be well served by conferring with council at length and seeking help from other jurisdictions that have more resources and experience, how they've addressed circumstances like this. My clients are concerned about the risk of a plat just getting out there that somebody would buy on and say, you know, I can build on this, when that doesn't seem to be even the intent of the Planning and Zoning Commission, as far as I can tell.
So if their future development phases were to be reviewed you feel that they should be reviewed under the 2019 ordinance, even if the subdivision was approved under the 1999 ordinance?
No, I'd have to think about that and look at the circumstances and what was the approval. My view, and agreed, I'm an advocate, is that the 1999 doesn't apply because the 2019 has come into effect and the developer has not established vested rights in the 1999 ordinance.
Okay, thank you. All right, anybody else?
Mr. Chair.
Commissioner Murillo.
So I had a question for you. So you said that there was incomplete records and you specifically identified the amended appeal of the decision that you submitted on May 15th. I note that it looks like it's cut off. How many pages were there supposed to be?
2 pages are missing there. And I touched those briefly speaking about them. There are some other things that were missing that I mentioned, and I have a list, but let me say that and why I'm complaining repeatedly about the timing of the record is that it takes time to go through a 3,800-page record and identify what's missing, especially if it's created after the fact. If the town had, for example, a date stamp system where they stamped when things came in and said it was filed on, like a court does, it's filed on such and such a date, here it is, it's in the record. The record's supposed to be consecutive, so you can find something that happened, and Ms. Agar has tried to do a good job, and I'm at odds with her on this, not because she hasn't done a good job after the fact, but if you've got a stack of documents and you're trying to reconstruct when it happened and you don't know what came in and what didn't, I mean, it's an impossible task. So the problem is basic and foundational to the record-keeping system of the town. And I might add on that, the town needs to, from my perspective as an advocate for neighborhood groups, it's the responsibility of the town to keep good records of how the hearings take place and what happens at the hearings. And from our view, a YouTube video that wasn't even cited in the record is not an appropriate mechanism for the town to keep records for quasi-judicial matters that may go up on appeal. I mean, you have to sit through, there are all kinds of errors, and I don't think the town even controls the YouTube videos, which are likely, can be pulled down at any time. The town should keep its own records, because the town is responsible. Let me just, I don't mean to go, but
So,
the town.
Can I interrupt you real quick?
Of course.
So my question, let me rephrase it. How many pages were there supposed to be
Of this record?
of your amendment?
Oh, the pages 4 and 5, of our amended appeal, pages 4 and 5 were
Are
missing
missing.
from the record. There were other, from our view, material papers that were missing from the record also.
Okay, and to be clear, I do see the YouTube video link that was provided in the records for.
Is that in the record?
It is.
I'm mistaken then. Where is that in the record? Excuse me.
Oh, shoot. Let me go back. It was on page, the reference number is 2190.
Well, and I have to confess, I have not reviewed the entire record, given the timeframes that are involved. Usually, when I've seen it, you have a index that that points out strongly or point boldly where is the video, and I'll just add that the video may or may not be an adequate way to look at a matter like this. It's very hard to write something based on a 6.5-hour video without an index. That should be indexed so you can go to a particular point and say this and that. Really, a written transcript is by far the preferred method on reviewing a trial, for example.
That's all I have.
Okay. Anybody else?
Mr. Chair.
Commissioner Anaya.
Sir, let me ask you this question. Again, we have to make a decision no matter what, up or down. And you brought up some good points about different ways that the city of Albuquerque does it. But Albuquerque is not, we're not Albuquerque. We're just country folk living out here in a small town who just happened to have tasked with a great big subdivision that's in Timbuktu. So we have to do something. My question to you is, and you mentioned this earlier about conditions. If the conditions were placed on the approval tonight, if it passed, would that be suffice for you?
Commissioner, I'd need to see, I'd need to have the findings and conclusions or findings and conditions and have time to consider them. In a trial setting, findings and conditions are fought about a lot. In this setting, the conditions are also often fought about at the Planning Commission level. Now, I know the Planning Commission put some findings in, but I don't remember any of them being dramatic or really powerful. And from our perspective, putting stuff on the plat is more effective than putting a condition on paper that just gets filed away. The plat is the public record document that people have to see. And if the plat says you can't build unless you have a preliminary plat and a final plat approval, the buyer of the property is put on notice that they got to go through the process.
Right, and that would be placed on it no matter what.
Well, our read of the is that wasn't going to be put on the plat. That's why we're bringing that up here. And
I think that's one of the conditions for P&Z on approvals.
that's maybe a condition, but not on the plat.
I'd have to get verification on that then.
Me too. I feel like
Okay,
I'm
I
dealing.
can ask this question. Mr. Hill, can you tell me yes or no that that condition, that one particular condition is part of the final approval on the plats?
It depends. But I think it's an important question, and I think there's an important answer. And when I get into my testimony, I'm going to specifically address that. And because I think there's a resolution that will satisfy all parties here. I mean, I can't say that for certain, but I know what the intent of the Planning and Zoning Commission was, and I believe I know what the desire of the community is, all of the community. And so I think this could, again, I'm not testifying yet, but you asked me a question.
Correct.
Let me get into my testimony and see if that answers what you're looking for.
Okay, because
And I have specifics.
I do have, same thing. Been sitting there writing down, if I were to make a motion, what would I motion? And a lot of things have been brought up, a lot of good ideas. You know, and my questioning is so that I could get a good understanding of what you guys were talking about.
Commissioner, if I may step forth a little bit here. You mentioned that you had to make a decision, but I don't think that's immediately true. You're entitled to take this, to confer about it, to go into executive session to talk about it. You can defer and cause the parties to talk about settlement if that's an option. You have a range of possibilities that you can exercise. You don't have to be forced into off the cliff or on the cliff.
But all of those are a decision that we, as a commission, has to make.
Yes, but again, you don't, I mean, I'm just saying, you don't have to say yes or no tonight.
That is correct. I understand that. But again, those are decisions that we, as a body, has to make. Whether it's let's extend this for another month, or whether it's, okay, these conditions might work. And so there's umpteen things that, there's 4 brains up here, well, 3.5, and I'm the half, that can come together with something.
Yes, let me suggest that that if that's a route the commission is inclined to go, that you allow the parties to submit suggested conditions or findings. And, maybe the parties would meet and confer. I'm just, there's it's a difficult matter. It could take a long time to settle out if people are going to settle it.
Okay.
Yes, sir. If I may.
Go ahead.
I think, Chair and Commissioners, I think we need to hear from the PNG, and then I think you can ask those questions to them. And after that, sir, I think I agree with Council that you have a various discretion, sir. So you can either, under the ordinance, you can either overrule, approve, modify, or directing PNG to reconsider with specific finding or conclusions. Make sure that you need to direct them to clarify some of the issue that you confronted today, which may, if some of the conditions, the question were not answered by the PNG today, you can ask them to come back with the answer. You can do that too, and then also you can asking for the parties to provide some briefing schedule, meaning that we want to know about your proposed findings and conclusion about this issue, and then ask them to present it within 30 days, and then you can entertain it if you want to. So
Okay,
you got various matters, sir.
Is there a possibility that, because it's not on the agenda, but could we go into closed session?
I think we have Open Meetings Act, so we didn't put that in, we didn't notify the public about the executive session, sir, so we cannot go at this time, but you can put it on the next, regular meeting or special meeting if you want to, sir.
Okay.
I think there's one more appellant. There is one more
Yeah,
appellant,
there was
Mr.
one,
Mull.
there's one more. As soon as we get done with MPAC.
I have 7. I have 7 requirements.
All right, so are you done with MPAC?
Yeah.
All right, oh, you're already standing up. We'll go on to the, Mr. Mall.
Hi, Commissioners. Thanks for meeting with all of us on a very difficult subject. My name is Mark Mull. I live in San Pedro Creek, and I'm testifying as a pro se appellant to the Town Planning and Zoning Commission's decision on May 25. I'd like to give you a little bit of history of my involvement in all of this. I moved here in 2009, the same year that Campbell and an entity from Nevada by the name of Vidler joined forces to create Aquifer Science, applied to the state engineer for 1,500 acre-feet of water, acre-feet per year of water to support the Campbell Ranch development. Static information, 1,500 acre-feet of water per year is 500 million gallons of water. B, okay, the joining of Campbell and Vidler, there was a compensation agreement between those entities, and Vidler provided 95% of the funding for everything that was going on in that activity. Campbell provided 5%. I served as the paralegal with the New Mexico Environmental Law Center on this project. The NMALC was supported by the San Pedro Creek Homeowners Association, the North 14 Forum, the Deep Well Protest Group, and many individual members in the East Mountain community. In 2009, Aquifer Science applied to the Office of the State Engineer, this is what I said earlier, for 1,500 acre-feet of water. Okay, it was rejected, denied by the state engineer in 2014, appealed by Aquifer Science to the 2nd District Court, which denied it in 2017, appealed again to the New Mexico Court of Appeals, which denied it in 2020. And then in 2021 was when the state engineer closed the Sandia Basin to everything other than individual domestic wells on individual properties. I'm going to try and not talk about water. Okay, I think you've heard a lot about water already, but I do have some concerns with considering the 1999 ordinance as the definitive ordinance. I agree very much with what Mr. Hess said about, Mr. Antimus said, about all of those issues. I also see an inconsistency in the way planning and zoning applies the ordinances. For example, in the statement of what was going to be able to be discussed here, we were all told that we could not bring up any new material. We were also given certain day restrictions, okay, to file appeals. Well, the 1999 ordinance, surprisingly enough, has its own language about how appeals are to be handled. And it says, any person aggrieved with any determination of the Planning Commission acting under these regulations may file an appeal to the town board. And think about it, there was a somewhat different governance structure in Edgewood at that time. Within 15 days of the Planning Commission's decision, such appeal, if heard, shall be heard within 60 days of its filing. The 2019-04 subdivision ordinance has a different somewhat set of rules. Let me go back for a minute. You heard that there was no comment in the 1999 ordinance about what could be brought up or brought into an appeal or into a hearing, and yet that was put into the documents that we were told we needed to file when we came in. Campbell continues to state that even though they are the current owner of the 1,200-acre subdivision, they're using Edgewood's resolutions and ordinances, but they cannot be responsible for the requirements of those documents. But if you look closely, in Section 9 of the development agreement, it says, binding this document, and this is the development agreement, is binding on Campbell, including its heirs and assigns, and the town. To me, that means that Campbell is stuck with all of its development agreement requirements until it sells or assigns any of its Campbell properties to a subsequent developer. There is nothing in the application that says that those development agreement Campbell requirements are going, what they are, and what they're all going to be transferred to the subsequent developer. Frankly, it doesn't say, does a developer get to use the 1999 ordinance, or can the developer use the 2019 ordinance? These are some of the kinds of things that Mr. Intima was talking about that I feel need to be specified before another developer, okay, gets involved in this project as to what are the rules that they are going to follow. Granted, I believe a lot of developers, no names mentioned, okay, would prefer to have a minimal amount of rules to follow. The constant approval of this project, this is me speaking, by both the Planning and Zoning Commission and the Town Commission, ignores several historical and significant legal decisions regarding the available, I am going to talk about water, and uses of water over the entire project, and probably an impact in the East Mountains. And I mentioned some of these dates earlier. In 2014, the state engineer denied Campbell's water provider, this was Aquifer Science, any water due to a lack of available water. In 2017, the district court denied Campbell's provider, this is Aquifer Science again, any water due to impairment to a large number of existing wells. In 2019, the New Mexico Court of Appeals affirmed both the state engineer decision and the district court decision. And then again in 2021, the state engineer closed the Sandia Basin, and I talked about that earlier. What we have is the state engineer who is responsible for managing New Mexico's groundwater resources. The New Mexico Judicial Court System, Bernalillo County, the largest in the state, and nearly all East Mountain residents that have attended these public hearings are opposed to Campbell Ranch, and in particular, this minor subdivision. Our governing bodies should respond by acting in line with the science, the legal system, the significant municipalities, and our constituents in telling you, please deny this application. I could go on to a couple of procedural things, one of which is to have only 4 days to go through a 3,800-page record, okay, of everything that's happened is an impossible task. And in a letter that Mr. Intima sent to you all, he suggested delaying this hearing. We didn't do that, but there are alternatives and there are conditions that need to be placed in this agreement that will force Campbell to, when it sells their stuff, to make sure that we, Edgewood and the town, are protected with what Campbell is allowed to deal with. I'm not sure how to make Edgewood a part of any deal that a signatory is probably the best way to say it, of any deal that Campbell would make with whoever would buy the property. It would appear, it's my summary statement, it would appear to this 20-year East Mountain resident that the appointed planning and zoning commissioners and the elected town commissioners have been overly enthusiastic and supportive of this massive land water infrastructure project. Now is the time for our local governing bodies to manage, control, and limit the significant impacts this and other developments can have on our environment and the quality of life that drew us to the East Mountains in the first place. Thank you.
Okay. Do we have any questions? Yeah.
Not trying to duck that. Questions?
Do we have any questions for this witness?
No, I have no questions.
All right. Commissioners, do you have any questions for this witness? I do have a question, but it's actually, I think only one can answer is Bernalillo County. And that question is, when you were talking, it struck it struck on me, and that's why I want to ask this. As far as Sandia Park and Paco goes, has any new construction permits been issued in the past year?
Mr. Chair, I don't know the answer to that, but I just don't know. I mean, I could check with some of my witnesses whether they know.
So, Dan McGregor, Bernalillo County. That's kind of a broad question. When you're talking about, are you talking about new subdivision applications, major subdivisions, building permits? I mean, you've asked a very wide-ranging question.
Well, this is also a wide-ranging issue.
No, that's fine. I'm trying to be responsive.
So I want to know, has anybody applied to start construction on any existing subdivisions or new subdivisions in that area?
The correct answer is I don't know. I can't imagine that there have not been building permits issued subsequent to some subdivision,
So building is still going on?
Yeah, so there are building permits still being going on. And I will qualify I know that for a fact because my group also permits septic systems, and I know that there have been septic permits issued in the East Mountain area. So I'm certain that there is construction permits that are being granted.
You have it on one end, it's got to be coming from the other.
Exactly, yeah, exactly. And we won't go into scatological professional humor here, but.
Thank you, sir, that's all I have. If nobody else has anything, that is it. Thank you, sir. All right, planning and zoning.
Okay.
Your witness has been sworn in.
I'd like to just a brief recess. I'd like 5 minutes to concur with council. We've heard a lot today, and I want to address what we heard today. And I want to make sure that what I'm going to say is appropriate, so I'd like to concur with council for 5 minutes or so.
Understood. If there's no objection from the commission, we'll take a 5-minute recess. All right, I have Well, I had one, then I lost one again. It's hurting cats again.
We need to go.
Right. If we can get everybody to start migrating to your seats, and as soon as the town attorney's back, we will get going.
It really is nice.
You're P&Z attorney. That's town attorney. Well, I had him, and I was missing you, and then you came in, I'm missing him. It's like herding cats. There we go. All right, everybody, let's resume. And we had left off with going to the planning and zoning.
Okay.
Pardon me?
Time. Resume that.
Resuming at 6:30.
Thank you, Chair Commissioners. So the first thing I want to state is that I have never felt at any time that the Planning and Zoning Commission or the Planning and Zoning Department is an advocate for any party in this matter. We are an advocate for the ordinances and applying the ordinances of the town of Edgewood. So the first determination, so the appeal is against the decision of the Planning and Zoning Commission. And I think the Planning and Zoning Commission took great effort to carefully review what they determined to be the appropriate ordinance, which is the 1999 ordinance. So I'd like to start by reading what they based that decision on, and that is a finding in the decision. So the ordinance, and this is an ordinance, this is the 2001-13 ordinance, and in that ordinance it states, in accordance with the terms and conditions of other provisions of this agreement and in compliance with applicable state and federal laws and regulations, the applicable rules for development, applicable rules of the lands governed by the Campbell Ranch Master Plan shall be those rules, regulations, ordinances, and official policies of the town relating to zoning, subdivision, and development which are in force on the effective date of this agreement consistent with the purposes of this agreement. Any change in the applicable rules, including without limitation, any change in the specific plan, zoning, subdivision, or building regulation enacted by the town after the date of this agreement, including without limitation, any change by means of ordinance, town charter, amendment, initiative, resolution, policy, order, or moratorium by whoever initiated or instituted and adopted, which would conflict with or be more restrictive than the applicable rules in effect at the date of this agreement, or would otherwise prevent or delay the implementation of the Campbell Ranch Master Plan in accordance with this agreement, shall not be applied to the Campbell Ranch Master Plan. The Planning and Zoning Ordinance read this, determined that they had no option other than to apply the ordinances, the ordinance that was in place by the town of Edgewood. Just like you, they swear an oath of office to comply with all ordinances, resolutions of the town of Edgewood. And so they felt that they had to apply the ordinance that was in place. So that's the starting point. And so understanding that, they determined that they would apply the 1999 subdivision ordinance. They felt that there was no other option for them. That's how they applied the law. And I think they in good faith, made that determination and applied the 1999 ordinance. Now, I will state, in my opinion, well, it's not my opinion, I think there is implied within the 1999 ordinance, it addresses all of the concerns that the community has brought forward. They're all in here. But, first of all, the application was for a minor subdivision.
So this is not a rehearing of the master plan. The master plan is zoning. Zoning applies. It has not been amended, it has not been altered. Every requirement and restriction in the master plan stays in place. All the restrictions in the agreement, which they previously cited to apply the 1999 ordinance, all of those conditions in the agreement stay in place. Those do not go away. They're 1999 and the agreement are still in place. This is not it. So this is not a rehearing of the master plan approval. This is not an application under the subdivision section of the ordinance that are under sections 10 through 17, which are those requirements that apply to a subdivision where development is going to occur. So utilizing the 1999 ordinance, any development, any building permit, any road development, anything of that nature, the 1999 ordinance has very specific requirements under sections 10 through 17. And I can get, those are specific requirements that have to be met. So again, under the minor subdivision section of the 1999 ordinance, there is no preliminary plat. It is a final plat for a minor subdivision, which in some way it's a bulk subdivision. It does not give the owner of the property any authority or grant them any ability to do any development. And that's how the Planning and Zoning Commission interpreted the ordinance, and they feel that it's implied in this ordinance that that is what the ordinance says. So they, you know, so let's talk about what has been proposed here, which is basically can we modify what planning and zoning did and put certain provisions or conditions on the approval. But what I would suggest is that we are in agreement that you can put a provision on the plat that if it's approved, that the property owner and subsequent property owners must comply with all development provisions that are identified in the subdivision regulations of 1999. So let me talk about what is in those provisions between 10 and 17. So under section 10, there does have to be a preliminary plat approval. So before anything is built, any development occurs, they must come back forward with a preliminary plat approval. So all of these items under the preliminary plat approval will then apply. So there are, you get into what the preliminary plat approval should look like. It's some technical, this is what a plat looks like, so it gives you conditions of what should be in the plat. There's also has to be storm drainage management, so we get into storm drainage, what the final plat procedure is, so you get a preliminary plat approved, and then if the property owner meets all of the conditions that are applied at the preliminary plat level, then they must approve the final plat. But what are those conditions that are going to be in the preliminary plat? So let me just draw your attention to section 14, which are the required improvements. And I'm going to draw your attention, because water is the big issue here, so I'm going to draw your attention to section C, item 3. And so this is before anything is built on any of this property, this is what they have to comply with. Water and sewer means the subdivider shall make necessary arrangements to serve each lot from water and sewer means where feasible and in conformity town board policy. Where for any reason municipal service cannot be provided, the subdivider shall provide evidence that adequate water and sewer service to each lot will be provided in compliance with the requirements of the New Mexico Environment Department and in conformity with the standard specifications of the town construction of all water and sewer lines shall be under the supervision and approval of the town. So no house is going to get built until they comply with a preliminary plat and a final, and the infrastructure has to be in place before the final plat is approved. So and you can look at the other, there's street improvements, there's drainage, there's electrical utilities. All of these items are addressed in the 1999 ordinance. They must be complied with before final plat approval is done on a regular subdivision. Development can only occur when there is a regular subdivision approval. And we can put that statement, that condition on that the 1999, all provisions of the 1999 ordinance will be complied with. I mean, that's the condition that I believe you've worded that something along that line, but that's the condition. I think if you put that condition on the plat, it satisfies every concern that we've heard here.
Was that the end?
So lines on a piece of paper do not give you the authority to begin development. What gives you the authority to begin development is an approval of a final plat based upon a preliminary plat approval. A minor subdivision does not give you the authority to initiate development. That's what the ordinance says. So I think what I'm saying is we can be consistent and comply with the 2001 ordinance and utilize the 1999 ordinance and satisfy all of the concerns that we have heard from the community. The developer is going to have to prove that he has wastewater, that he has roads in place, that he has electricity in place, that he has water in place. All of those things have to be in place before a final plat can be approved, so that there is actually, before they sell lots or houses, all of these conditions have to be met. Just like any subdivision that we are currently reviewing in anywhere else within the limits of the town of Edgewood.
Mr. Chair? Commissioner Reardon.
Just one other thing. Section 9 of the ordinance, so this preliminary and final, that's a two-step process. And this is or is this the minor? Okay, on the minor, there's a two-step process, which is there has to be a preliminary application review to determine that this is indeed a minor subdivision. That meeting did take place. The Planning and Zoning Commission did determine that the requested application and plat met the requirements of the minor subdivision section. And then the second step is to complete the final application process. So that it did they did determine that it qualified as a minor subdivision. And again, a minor subdivision does not allow for any, I want to stress what it separates from development. So say what you will about, it's an old ordinance, but it actually has a lot of teeth. It has a lot of protections for both, and it is if we do this, if we can agree that yes, the ordinance applies, the subdivision ordinance applies, it gives protection to both the applicant in that he met the requirements of what the agreement was, and he meets the requirements of the subdivision, but he understands also implicitly that he cannot develop until he comes back and conforms and complies with all of the requirements of sections 10 through 17. And if you want to take the time and go through those or ask me questions of those are not, that's not cutting corners. And anybody who says that the town is cutting corners, that is not the case. So. I guess I'm done.
Okay. Commissioner Reardon.
So if we get to the preliminary stage, and we've heard evidence that there is definitely an issue with water, so all basins are closed for any new development. That's going to be standard. And then, sir, you mentioned that there's a requirement to demonstrate that you have water before you do anything, and I suspect that that will be in this preliminary stage.
It's required by the ordinance. It's not, you think we will apply the ordinance, that's what we're saying. And we've always had the intent to apply the ordinance. And it's very specific what those requirements are.
And during this stage, all the infrastructure issues would be addressed by the developer in concert with the town? So i.e.
at the
police?
preliminary plat, it states what has to be in the preliminary plat. It's all of these requirements. And we can approve a preliminary plat and say, okay, yeah, you're going to, and he says, if the applicant, any applicant says, I'm going to do all these things, and that's fine, but you don't get final plat, you don't get to go to the county clerk and file your plat until everybody is satisfied that all of this infrastructure is in place. That's how subdivisions work. A minor subdivision, again, the intent, and I'll go back historically just briefly because I was, I am a life member of the, resident of the town of Edgewood. The idea of bulk subdivisions or a minor subdivision, we colloquially called them back in the day family splits because as you know, the Estancia Valley was settled by homestead families that had large parcels of land, and most of them had large families, and through the generations, those lands were divided among their children and their grandchildren. And you could not impose these kinds of development restrictions if you wanted to just, will property to your children. You had to go through this family split process. So we still have large family holdings in the town of Edgewood, and there is still a need for these types of bulk divisions, and appropriately so. But by a family split does not give you the right to go out and sell lots to the public. You still have to go through the subdivision process. That's what we've always done, and that's what we will continue to do.
And his vested rights would not come into play until the preliminary part.
So if you give a preliminary plat approval and the applicant puts in all the infrastructure, they then have that. You can't come back and say, well, you put the infrastructure in, and the ordinance actually says if they meet all of the requirements that were imposed upon them at the preliminary plat stage, the commission must approve the final plat.
Understood. Thank you.
But if they don't meet all the conditions, they don't have to approve a final plat. They would not approve a final plat. There's no option there. It's not a gray area. It's black and white. Here's what you have to do. If you do it, you get final. If you don't do it, you don't get final. And there's a time period.
I don't have any more questions. Thank you.
Okay.
Mr. Chair.
Commissioner Murillo?
So I had a question for you. So at the beginning, you were talking about the applicable rules, and you said that Camel Ranch had exemptions already in the ordinance?
I read the ordinance to you. I can read it again if you'd like.
Please.
Okay, it's, well, this is a long paragraph, but it's kind of the key, it's a key issue, and it was the first finding that the Planning and Zoning Commission made in their decision in the hearing. This was the first finding that they determined.
Because my question really was, because at the beginning, I don't know how long it's been since you started, but at the very beginning, you were talking about how Campbell Ranch had exceptions, and that it was already in the 1999 ordinance.
No, they don't have exceptions in the 1999 ordinance. They have a rule, under rules for development, in the development agreement, which was established in town ordinance.
Were you talking about the provisions then?
The name of the ordinance is an ordinance establishing zone districts for certain lands annexed to the town of Edgewood, New Mexico, and land specified in agreement A1A. So this is an ordinance that was passed by the town of Edgewood in 2001.
Can you read that?
I can't, the pertinent agreement section is rules for development. And it says, in accordance with the terms and conditions and other provisions of this agreement and in compliance with applicable state and federal laws and regulations, the applicable rules for development, applicable rules, under quotations, of the lands governed by Campbell Ranch Master Plan shall be those rules, regulations, ordinances, and official policies of the town relating to zoning, subdivisions, and development which are in force on the effective date of this agreement. Effective date of the agreement was December 3rd, 2001. Consistent with purposes of this agreement, any change in the applicable rules, including without limitation, any change of the specific plan, zoning, subdivision, or building regulations enacted by the town after the date of this agreement, including without limitation any change by means of ordinance, town charter, amendment, initiative, resolution, policy, order, or moratorium by whoever initiated or instituted and adopted, which would conflict with or be more restrictive than the applicable rules and effective on the date of this agreement, or would otherwise prevent or delay implementation of the Campbell Ranch Master Plan in accordance with this agreement, shall not be applied to the Campbell Ranch Master Plan.
And what number is that in the document?
This is the ordinance. I don't know what, if you can, it's the.
51.
We found it earlier. I think you were given a copy of it. Not-
Yeah, I was just looking for it.
Yeah, it's in here. While we're looking, can I give you one other, I think, important piece of information? So, again, okay, so the Planning and Zoning Commission and this governing body all swore an oath to abide by the ordinances and resolutions of the town of Edgewood. I will remind the commissioners that there is an existing resolution that has never been rescinded. That states the town of Edgewood will not support in any way the removal of water from the Estancia Basin. Keep that in mind. Okay.
Yeah, you found it.
Yeah, thank you.
So my next question, so my question is, why didn't the Planning and Zoning Commission just tack on the provisions initially?
Because it's implied in the ordinance, and they felt that they were complying with the ordinance. I understand, I agree. I think, quite frankly, I think Mr. Garcia gave us the resolution to this in the first 10 minutes of this hearing, which is to put that condition on the approval of the of the minor subdivision. And I think Mr. Heitman's, some of his appellants made the same argument. And I think in a certain way, Mr. Heitman's made that argument. I think it satisfies the concerns that we're hearing. I think the public needs to understand. The state engineer is specifically, the state environment department is specifically cited in the subdivision ordinance that they have to meet the requirements of the New Mexico Environment Department regarding water usage and wastewater usage. There's no leeway here. The town of Edgewood is not advocating for this development. The town of Edgewood is advocating for applying the laws of the town of Edgewood.
Do you believe the provisions that were set forth in Ordinance 99 will ever be satisfied?
You're asking me to speculate on something. I would not even give you a speculation on that.
Okay.
You can draw your own conclusions on that.
That's all I have.
Okay. Commissioner Naya.
Mr. Chair, Brad, with what you wrote actually is what I have written here, except for it's in detail. As to each little item there that says provide the roads, 40-year study of water, all the water rights, the ability to have law enforcement. There's one other thing that that is not on that, and that is that the builder must supply a bond.
A barn?
Bond.
Oh, a bond.
Yeah, a barn too. Now, I don't know if we can.
No. So there is a provision that in lieu of putting in the infrastructure, the applicant at a preliminary plat approval can submit a bond that's estimated to be equal to the cost of putting in the infrastructure. But you still can't get final plat approval.
Well, I was just thinking of more of a
That
financial security.
Well, I mean,
for the town.
Once the infrastructure is in place, the infrastructure is in place. And that final plat approval does not occur until that is done.
Okay.
And I think, I think you're better off referring to the ordinance, because if you look at sections 10 through 17, they're pretty inclusive and pretty detailed. I think you have to rely on the ordinance. I think that's I'm not going to give you legal advice, but I think it encompasses everything that you want. It covers everything that I'm hearing from the community. It covers, I think, what your concerns are. It covers I think, the intent of basic land use.
So they do have to provide water before one rock is moved, and...
Well, no, they get to move rocks to put the water lines in.
I understand.
But they can't sell anything.
Right.
Until the final plat is approved.
All right, we did jump the gun a little bit here because we had, MPAC needs to have the opportunity to cross-examine. So, hang on to your stuff. And
Mr. Chair, if you don't mind, Bernalillo County goes first since we went first on the appeal.
Sure.
Okay. Mr. Hill, just a few questions, and I'm not going to play gotcha. I just want to establish some things for the record.
Use the mic closer, please.
I don't think I can get it much closer.
Or are they still?
I don't want to get it much closer.
Okay.
Can you hear me?
Yes.
Okay. So, and the concern of this, I'll just preface the questions with what the concern is. The concern is to clarify that probably Bernalillo County and probably most of the residents don't want a proliferation of domestic wells. And so the question that I have for you is, regarding the master plan, does it call for a centralized water and wastewater plan?
Yes.
Okay. And would that, a demonstration of such a plan be preliminary to an approval of development?
So,
Or a plat?
yeah,
too?
so one of the things that you do have to look at the preliminary plat stage, is this in conformance with zoning? In this case, master plan zoning is the zoning, and the master plan has specifics as to wastewater treatment plants. It also, it gets into some other stuff, but yes, the answer is yes.
And that would include the preliminary plat stage as well?
Correct.
Okay. Is there any regulation, is there any regulation in the master plan of individual domestic wells, private domestic wells?
I have not seen anything that specifically precludes it, but the master plan definitely states that there will be a water system serving subdivisions.
Okay. And then the last question, the resolution that you mentioned regarding not transporting water out of the Estancia Basin, could you get the number for that resolution? So
I don't have it in front of me, but yes, I have it in my office. Yes.
Just sometime in the next few days?
Absolutely, I can get that to you.
Thank you, sir.
I was on the governing body when that was adopted.
Okay, appreciate it.
Okay, Mr. Hill, what's your position with the town?
I am the Director of Community Development.
And how long have you been with the town?
In what capacity?
In any capacity?
I was appointed to the Planning and Zoning Commission, I believe, in 2005. I became a town commissioner, I believe, in 2008. I became mayor in 2012 until 2016, and then I came back to the town. You're talking about my government positions, isn't it?
Yes.
And then I came back to the town as planning and zoning manager. I believe it was 2022? When did you, 2022.
Okay, so are you currently an employee of the town?
Yes.
And do you consider yourself, aren't you a trusted and respected, a valued employee of the town?
I would hope so. I will mention I also represent all municipalities in the state of New Mexico on the board of directors of the New Mexico League of Zoning Officials.
And do you work with the commissioners on various projects? The town commissioners here?
Yes.
Without going to, but what type of projects do you work with them on?
We're currently, I work with the Economic Development Department. I am on a technical advisory committee for looking at solid waste programs and water programs specifically. But beyond that, I am under the supervision of the town manager.
How long have you been working on this application?
The original application, I don't remember when the original application came in, but it was the first hearing of this original application, yes.
And how long? Have you been working on this project for years?
This application?
Yes.
No, it's been maybe a little over, I don't know if it's quite 2 years.
And how did that start? Did the developer come to you and ask for your review of it?
The developer submitted an application, and
you had meetings with the applicant and discussed their project?
We do a pre-application review with all applicants.
Okay, and that's on behalf of the town?
Correct.
And ultimately, there were some hearings, and you're here today to argue in favor of the Planning and Zoning Commission's decision?
Yes. I would say argue in favor of their process. I have no, whatever their decision is their decision. What I'm here to do is indicate that I believe that the Planning and Zoning Commission properly followed process.
Did you make a recommendation to the commission?
We made a recommendation to apply the 1999 ordinance.
Did you recommend to approve the bulk land plat?
I don't recall, on this most recent one, I did not, because I was not planning and zoning manager at the where this was approved.
Okay. Well, let me ask, would you agree that this is a bulk land plat?
That is what, yes, I believe it is, because that's in consultation with legal counsel, yes.
Is bulk land plat mentioned in the 1999 subdivision ordinance?
No, it's not specifically identified as a bulk plat, yes, I agree with that.
What do you understand to be a bulk land plat? Bulk land subdivision
Okay,
plat?
so as I stated, I mean, I just historically, I mean, from a basic land use perspective, it is a way to divide land into larger parcels, not with the intent of individual development on those parcels, but it's for whatever financial or business reason, or family reason, or divorce, or legal settlement, that land, there are certain conditions where lands should be able to be divided.
And is it your interpretation that a minor subdivision is essentially a bulk land plat?
Yeah, I am following what I believe in the 1999 ordinance to be a minor subdivision.
Okay, let the record reflect that he conferred with counsel before answering that question. And I'm sorry, can you repeat your answer?
So I believe what happened in this case was an application of a minor subdivision.
Yeah, but my question is, does a minor subdivision contemplate a bulk land plat? Are they the same thing?
You're asking me for a legal opinion?
Okay.
I'm not going to give you a legal, I'm not an attorney.
But you treated the bulk land subdivision like a minor subdivision, did you not?
I treated the minor subdivision like a minor subdivision. It has, I think, consistencies with what is generally considered within land use law a type of bulk subdivision.
And can you cite any land use law for the definition of bulk land subdivision?
I can't, not off the top of my head, no, sir.
Okay. Now, let me ask you, if you look at pages, I think they're 3279 and 3280 of the record, that's where we submitted, the appellants I submitted on their behalf, objections based on vested rights. Did you review that part of my argument for?
I saw that you indicated vested rights. Yes.
Did you read any of the cases?
I did not read the cases, but I have some familiarity with what a vested right is.
Did the commission consider any of this in its measurement of vested rights?
Vested rights are not identified in the subdivision ordinance? I can't, yeah, and I can't speak for the commission. I did not advise them on vested rights. I can say that, but I can't.
You earlier testified that you had vested rights came from a legal counsel. You had an analysis of vested rights from legal counsel. At least that's what I understood you to say.
I don't believe I said that, sir.
I could be mistaken.
I apologize. I don't believe I said that.
So you were there and you presented, did you present at the Planning Commission?
No.
And you can't say whether the Planning Commission considered the legal argument that we raised before them? Did the Planning Commissioners consider vested rights?
I can't speak to what they did or did not consider.
Well, aren't you here to testify on behalf of what you're defending their decision?
I'm saying that they did apply the 1999 ordinance.
And my question...
And there is no specific language in this 1999 ordinance regarding vested rights.
So did you, let me ask a couple more questions here. Well, I've got a note excuse me. So I've been given here, oh, this was in the record, I'm not sure where it is. It's the memo from Nan Winter to you about vested rights on May 15th of 2024. Do you recall that memo?
I don't know it by the date. I know that I have had communication with Ms. Winter.
Okay, did you discuss this memo with the planning commission?
I don't know what memo you're referring to, sir. I'm sorry.
Let me hand you a copy of it. And I regret that I don't have, commissioners, sufficient mental acuity or authority of the record to find this. I do know that we presented it at various times in the record. It's just at this moment I'm not able to put my finger on it. And let me point out for the record that he's consulting with counsel before answering this question.
So this memo is in the record.
Okay. Did you advise the commission about this anyway?
Sorry, I didn't even get to look at it.
You didn't look at it?
Let me look at it again, if you don't mind. I apologize.
Okay.
So I want to make sure I'm speaking, we're on the same page here. Okay, now I know what you're referring to.
Okay. Did the commission, through you or otherwise, consider this?
I don't believe so.
Okay.
Again, I don't know, you're right, I'm sorry. I don't know what the commission did or did not review outside of what I was aware of in the meeting.
Okay, and this, Commissioners, this is at 2186, I'm advised, in the record, this particular memo. And so did you guys, were you able to find that the video was identified in the record? It is in the record? Could you tell me the page of that so I can, if I get another chance, I'll look and see?
June, you had it, I believe? The reference to the video, to the YouTube video.
Excuse me, 53.
I think it was 2153.
2153.
Or was it 2153?
Okay. Okay. Does the town have the video?
Yes.
Is it YouTube's property or is it the town's property? What's the circumstance of that?
It's in the public domain, I believe. I don't know the answer to that. I'm not I don't know the legal ownership of the YouTube video. I know anybody can access it.
Okay.
And I know you're not asking me, but I will tell you that, I don't know if I can say this, it has to do with ADA requirements, that's what it is. Okay, so, okay, all right, okay.
Okay. Well, not to belabor this, but let me give you a hypothetical question. Would it be conceivable that the board, the commission, could consider and enact a bulk land subdivision provision?
I believe under state statute, local governments have the right to enact ordinances. That was how I was.
So the board could enact a bulk land subdivision ordinance provision?
I need to object because this isn't questions about the record. It isn't questions about the ordinances before this commission. And he's asking him to speculate hypothetical that hasn't been asked before. And it really, I mean, we can't, he's asking to speculate, so I object to this question. And it's also not part of the record. He has to just move on to the next question.
Sure, I'll have to agree with counsel. Please move on.
Chair, Commission.
Yeah, get your.
YouTube video is located in basement number 1183.
And I will just state that YouTube recordings of meetings are consistent with recommendations from the Attorney General's office regarding ADA compliance of the record, because it gives It gives the opportunity for transcription in the video, and you can do language translation. So it's actually, it's one of the protocols that the Attorney General, under the ADA guidelines, approves. So.
Okay. If, I don't have any other questions. Thank you, Your Honor.
Okay, thank you. Commissioner Knight, go ahead, pick up where you left off.
I forgot.
You got it written right down in front of you. Or you want me to go ahead?
Go ahead. I'll bounce off.
All right, my first question on this, part of it's been kind of answered, but I'd like to be more specific, and that is, what is the Commission's interpretation of the 2001 Development Agreement regarding the applicability of the 1999 ordinance to Campbell Ranch?
What is the Planning and Zoning Commission's opinion?
Yeah.
They reviewed it. They actually, if you look at the notice of decision, if you look at finding 1 on page 3, it says adopted December 3rd, 2001 by the governing body, the Town of Edgewood Ordinance 2001-13, Section 4. Rules for development establishes the applicable rules for development, and it goes through that, and it indicates that under this ordinance, in the place at the time of adoption of the established agreement would apply under the applicable rule definition. This was their finding, that the 2001-13 ordinance applies. That is their first finding.
Okay. And so what's the main differences between the 1999 R and the 2019 ordinance?
So the 2019 ordinance does not have a provision for a minor subdivision. It has a provision for what is called an expedited subdivision. They're similar but somewhat different. As far as generally speaking, the rules and requirements for a preliminary and final plat are the same for a normal, regular development type subdivision. They're very similar.
So what would you say is the main number one difference here is the fact that they don't, 1999 doesn't reference the minor subdivisions?
It does not. I'm sorry.
You said 1999. 1999 has it.
Yes, the 2019 does not.
Doesn't have, okay. Would the commission agree that the approval of a bulk land subdivision does not confer developmental rights, and that further platting and infrastructure approval are required before development can proceed?
Let me review a little bit. I will tell you, I'm not sure if they did a specific finding. I think they just limited their discussion to the requirements of the minor subdivision. There was general discussion, and I think they stated, as I recall, and you'd have to go to the video to confirm this, but I'm pretty sure they clearly stated that what they're approving, and I think they all stated this quite emphatically, does not allow for any development to occur. They stated that quite clearly in the meeting.
Okay. And what assurances are in place to ensure that each tract created by this subdivision will undergo full review before any development will occur?
That's just. I'm sorry, could you restate your question, sir?
Sure. What assurances are in place to ensure that each tract created by this subdivision will undergo full review before the development occurs?
So, okay. So under section C of 14, section 14, it says installation of improvements, the subdivider may prepare and secure approval of the preliminary plat and then install improvements in the area covered by the preliminary plat. Improvements must be installed only in that part of the area for which the final plat shall be submitted for approval and filing. The improvements to be installed shall include the following: subdivision and control management, street improvements, water and sewer main, drainage, electricity, gas line, telecommunications. All of those must be installed. That's what the ordinance says.
And you said that was on section 14C?
That's under the subdivision ordinance, section 14. Under required improvements, section C.
All right, that's the installation of improvements.
And it also, it says above that, installation assurance. Plans for improvements shall be prepared by an engineer registered in accordance with the laws of New Mexico. The town is to be assured of the installation of these improvements in a satisfactory manner by one or more of the following methods: complete installation of improvements prior to the approval of the final plat, and then submission of a satisfactory bond, and completion of an approved assessment procedure by which the town is put in an assured position to do said work and make said installations at the cost of so the town can put in the improvements and then at the cost of the developer. I don't know that we would ever do that, but that is an option. But basically, complete installation of the improvements prior to the approval of the final plat, and in any and there has to be grading and drainage done by an engineer. If there's more than 10 units in a subdivision, the roads have to be approved and designed by an engineer. And so so for those technical aspects, there has to be assurance in, an affidavit or signature from an engineer on the plat, final plat, that those improvements are in place in accordance with the engineered proposal. And then as far as electrical and telecommunications, there is a signature line on the plat, on the final plat, that must be signed by a representative of that utility that those installations are complete to the satisfaction of the utility.
Okay. When you said 10 units have 10, is that 10 lots or 10 houses
10 lots,
under
I'm sorry,
construction?
10 lots. I
Okay,
meant
so
10 lots.
it just says 10 lots, doesn't have to be a house being built. So you get 10 lots, some guy builds one house, it's still they have to provide.
You cannot get a building permit. The town will not give you development review where you can get a building permit until there is a final plat in place. It is a criminal misdemeanor to begin construction before the final plat is recorded with the county clerk.
Okay, thank you.
Mr. Chair,
Commissioner Naya.
along those lines, Brad, about the inspections, the State Department does do inspections on all utilities. They have to sign off on it.
So that's part of the process that there's a development agreement between the developer and, let's say, in this case, it may be it could be P&M. So they have to have a development agreement with P&M at preliminary plat, not just final, at a preliminary. And then at final, there has to be signature from the utility that those improvements are in place and have been approved.
So, and going forward, will the commissioner be requiring future development applications for each tract to comply with sections 10 through 15 of ordinance 1999R?
10 through 17.
So 10 through 17?
I think that's what we indicated, yes. It's actually the entire ordinance, but yeah. But specifically 10 through 17, or 10 through 15. But there's a section on road classification and design. Those have to be met. Drainage has to be met. Easements have to be properly identified. The character of the development has to be met. And then any modifications or exceptions have to be approved specifically. So they can't just say, hey, we're going to modify this a little. Well, if they're going to modify it after the preliminary plat, they have to come forward for approval, that modification.
Okay. Then, so how's the commission going to ensure that the infrastructure requirements such as water availability and drainage, road access, et cetera, are addressed in future development phases? What's the process going to be for that?
For future development, it's the same process.
Okay. Then,
Any phase that requires development has to comply with all of the subdivision ordinance requirements.
what is the standing that says we have to follow the 1999R ordinance?
Again, it's the ordinance 2001-13 that I read to you earlier. That is the,
So in order for us to be able to apply that ordinance, doesn't...
Apply what ordinance? Which ordinance?
1999R.
The 2001 ordinance, which is a legally binding ordinance that states that we have to use the subdivision ordinance that was in place at the time of this ordinance. At the time this ordinance was passed, the 1999 subdivision ordinance was the subdivision ordinance in place at that time.
Okay, and then we had, time went on, and we had the 2019 ordinance came along. And from what I've been reading and studying on this, is that in order for the earlier ordinance to apply, there has to be some sort of vested rights by the developer in order for it to apply. That's what I mean, that's the way I've been reading everything.
I can only tell you what the Planning and Zoning Commission did. They reviewed, because they are sworn to apply, again, laws and ordinances, but they specifically and indicated through their finding that they looked at an ordinance that was in place from the town of Edgewood that required them to utilize the 1999 ordinance. I think that was the agreement between the town of Edgewood and Campbell when they came in for annexation. So that's an agreement between the town and Campbell that this is the ordinance that will be applied referring specifically to the 1999 ordinance.
Okay, thank you. Commissioner Nair, go ahead.
Okay, so.
I'm actually okay on that.
So I'm not an expert on investment. I will, well, one, there's a matter of law that establishes that this is the ordinance that applies. So that could be, I think, I'm not an attorney, but I think that could be considered a investment. But you also heard testimony that the applicant spent tens of millions of dollars on this project. That was testimony from an appellant. And from the applicant.
Mr. Chair.
Commissioner Murillo.
Mr. Hill, could you read section 14 of ordinance 1999 for me?
Are you reading?
I'm sorry.
He asked you to read section 14.
No, Mr. Hill. I asked
Oh,
Mr.
I'm
Hill.
sorry, I thought you said.
No, Mr. Hill.
I'm sorry, I apologize.
I can't
I
say your name.
apologize. Okay. Authorization. Receipt of the signed copy of the preliminary plat is authorization for the subdivider to proceed with the minimum improvements required by these regulations prior to the construction of any improvements or to the submission of any bond. The subdivider shall furnish the planning commission with all plans and data necessary for the construction of said improvements. These plans shall be examined by the planning commission and will be approved if in accordance with the following requirements. Following preliminary plat approval and an improvement agreement, construction can be started or the amount of bond determined. Installation assurance. Plans for improvements shall be prepared by an engineer registered in accordance with the laws of New Mexico. The town is to be assured of the installation of these improvements in a satisfactory manner by one or more of the following methods. 1, complete installation of the improvements prior to approval of the final plat. Submission of a satisfactory bond, either a performance bond or a cash bond, or the establishment of an escrow account in the amount with the surety and conditions satisfactory to the town clerk, providing for and securing to the town the actual construction and installation of such improvements and utilities within a period not to exceed 1 year. Or completion of an approved assessment procedure by which the town is put in an assured position to do said work and make said installations at the cost of the owners of the property within the subdivision. C, installation of improvements. The subdivider may prepare and secure approval of the preliminary plat and then install improvements in the area covered by the preliminary plat. Improvements must be installed only in that part of the area for which the final plat will be submitted for approval and filing. The improvements to be installed shall include the following: subdivision control monument. All subdivision boundary corners and the 4 corners of all street intersections shall be marked with subdivision control monuments. Should conditions prohibit the placing of monuments on line, offset markings will be permitted, provided, however, that offset courses and distances are shown on the plat. A permanent benchmark shall be accessibly placed within the subdivision, the elevation of which shall be referred to in the USGS datum and accurately noted on the subdivision plat. At least 2 monuments shall be referenced to the New Mexico State Plane Coordinate System. Street improvements. All streets shall be graded and the roadway improved by adequate surfacing under the supervision of the town and subject to approval in accordance with the design standards provided herein. Water and sewer means. The subdivider shall make necessary arrangements to serve each lot from water and sewer mains where feasible and in conformity town board policy. Where for any reason municipal service cannot be provided, the subdivider shall present evidence that adequate water and sewer service to each lot will be provided in compliance with the requirements of the New Mexico Environment Department and in conformity to the standard specifications of the town. Construction of all water and sewer lines shall be under the supervision and approval of the town. Drainage. Construction of drainage improvements and other means of stormwater management shall be under the supervision and approval of the town. Electricity, gas lines, and telecommunications. Commitments must be requested from franchised or private utility systems when such acceptance is deemed appropriate by the Planning Commission. That's section 14.
So to follow up on that, so the application was to divide into 5 tracks. Does section C, 14C, does that mean they can go ahead and secure approval of the preliminary plats and then install them prior to dividing that further, or can they do that with the current tract 5
No.
system?
In order to create developable lots,
Right.
in order to be able to get a building permit, in order to be able to sell a lot, they would have to come forward within one of those 5 tracts that they're creating. They would have to come forward with a preliminary plat approval. And they would be subject to all of those conditions. And all of those, whatever is identified in that preliminary plat approval has to be in place before the final plat can be approved. And they cannot build, get a building permit, sell a lot, advertise the sale of a lot, put out a prospectus to sell a lot until that, they can't even refer to those lots legally until that plat is recorded in the county clerk's office, in this case, the Bernalillo County Clerk's office.
So this wouldn't.
And they can't record that in the Bernalillo County Clerk's office until it's signed off by the town manager, the town clerk, the Planning and Zoning Commission, all the requisite utilities. And then they also have to, it has to also be signed by Bernalillo County Land Use, Bernalillo County Assessor, the Treasurer's Office regarding currency of property taxes. And when all those signatures are secured to indicate that compliance, then they can submit it to the county clerk for filing. After it's filed with the county clerk, they could come in and apply for a building permit.
So section 14C won't kick in until another application.
Until they come forward with a preliminary plat, yes.
So it won't kick in until then.
But they cannot get a building permit, they can't sell those as developable lots. They can sell the bulk land, but they can't purport that those are lots can be developed until there is, and you can put this on the plat. This is what we're recommending that you do, make a condition that compliance with the subdivision ordinance must be in place before any development occurs.
And that rule also applies to whoever buys.
It's on the plat, it's on the plat.
Somebody goes out and buys.
It gives fair notice to whoever the
Tract
buyer.
1 of the subdivision, the rules will apply to that person purchasing.
So let him ask this question.
Okay.
And then answer.
I'm sorry. I stepped over your question. Right. So what I'm being advised, the language to use is that any buyer that purchases one of these lots steps into Campbell's shoes and must comply with all of the development sections within this ordinance before they can do any development.
Do the current zoning regulations that we have in place, because we have a zoning for an R1, R2, et cetera, those zoning regulations apply to all this land?
This land is currently zoned master plan.
Well, I know, but, I mean, once they go ahead and start requesting, because in order to go, before they can build, they're going to have to go and rezone.
So maybe. Before they sell lots, they're probably going to want to rezone, but I can't, again, that's a separate issue, and I don't, but
One of the things I keep on hearing people saying, the big fear that all these are going to be a little quarter-acre lots. And in my review of our zoning ordinance, the smallest lot available is a 1-acre lot, and that's under R1.
Under R1, the smallest lot. Now, under a master plan, there could be higher density. So there is provisions for higher density under R3, under C2, under master plan, so it depends. So the master plan that they currently have has established zoning density. So there's only X number of lots they can do. They can move them around. They could have a bunch of small lots and a giant open space, or they can spread the lots out, but there's only, the density requirement is established under their master plan agreement. So they don't get to come in, so they could have areas where there's higher density, just as we have in Edgewood. We have established zone districts where you could do townhomes, for example. But you still have to have a certain amount of open space to be able to do those townhomes. So you're getting into zoning questions, and those would all be applied at a subdivision review. So if they, say you have a 100-acre lot, and under our guidance, that means you can only do a maximum of 100 houses, which is 1 acre per residence, and you have to factor in roads and everything else. So let's say you have 100 acres, that means you could do theoretically 80 single-family lots, let's say. Or you could do 2 40-unit townhomes on 10 acres and have 90 acres of open space around it. That's how that works.
Okay, and you keep on talking about the master plan. Is the master plan considered to be a binding document that has to be followed? Or is it an
It's zoning. It is zoning. Yes, you have to follow your zoning.
But what's in the master plan itself?
Yes. Now, master plans are conceptual to a certain extent, but what I think, the way I read the master plan, the density is established. So, a maximum number of units for the acreage that they own. And they can configure that, they can arrange the deck chairs in different ways, but, what probably would not be a good idea if you have 1,000 acres is to do 1,000 single-family lots. That just doesn't really make, doesn't make good. There's also a section in here on subdivision character. So the Planning and Zoning Commission could look at that and say, you know what, your subdivision doesn't really fit in the character of the town of Edgewood. We want you to give more open, you need more open space. We need parks, we need this, we need that. So those are all kind of, again, master plan zoning is kind of performance-based zoning. It's not Euclidean zoning in the traditional sense. So it gives the developer a certain amount of leeway, but the actual density is established and cannot be waived or cannot be, there's no variance for that, for the density.
Now, the master plan, was that estimated, what, 2002? The original?
It sounds right. It might have been modified later. I'm not sure. There was they did come forward with a request to eliminate a golf course, but the community came forward and said, no, they didn't want them to eliminate the golf course.
Because I know after 23 years, things change.
Yeah. And this was not the town of Edgewood. It was basically the same people that we're hearing.
Right.
Came forward and said, no, we can't. We're not going to allow you to modify your master plan to eliminate the golf course.
Yeah, I remember that. It was, I think that happened in November of 2021.
2021, yes.
Yeah, and the first meeting went to like 1 o'clock in the
They
morning.
violated Open Meetings Act and they became invalid.
Right. Okay.
Mr. Chair.
Commissioner Mario.
Mr. Hill, do applicants ever indicate what they're intending to do with their applications?
do with their application.
Yeah, so with this application, did they indicate what they were planning on doing with it?
They're creating 5 lots.
And that's, they didn't give any reasons
We
why?
don't, yeah, if the applicant wishes to divulge that, that's their prerogative. If they choose not to, we can't require that they do that. That's not an appropriate mandatory question to be answered.
Yeah, that'd be like if I'm selling my house, I don't have to give anybody a reason why I'm selling my house. Okay. Just wanted that for clarification.
What I will tell you is they are bound by what is permissive on that lot. So in this case, what is permissive is basically you have a lot. And you have lines on a piece of paper defining that lot. And you can convey that lot, but you can't build on it.
And until that point to where they go through all the process and they're ready to go ahead and drive the first nail, they're going, any changes to zoning within the town of Edgewood, they would have to abide by by those changes.
Correct. And property rights, property owners have the right to request a zone change. So, I mean, we can't preclude, say, nope, once you get a zoning, it's in perpetuity, you can never change your zoning. That's not legal.
Well, no, I'm saying like, if, just a hypothetical thing, we go and we change the R1 zoning from 1 acre to 1.5 acres. So that.
If they apply for R1 zoning after that change has been made, they are subject to that stipulation.
Change. Okay, thank you. So at what point in the process is a formal development plan expected to be submitted and approved? And how does this timing align with the requirements of the zoning ordinance and subdivision regulations?
You'd have to define development plan. So development plan can be citing a house on a plat. So if you have a 1 acre lot and you come in with a development plan that shows, okay, I'm putting my house 60 feet from this lot line, 60 feet from this lot line, 45 feet from this lot line, and 120 feet from that lot line. That's a development plan.
What I'm referring to as far as development plan, as far as these lots 1 through 25.
That's a subdivision plan. That's a subdivision. That's not a development plan. That's a subdivision. This is what we're talking about.
Okay.
So they come forward with a plat and saying, okay, here's the roads, here's what the lots are going to look like, here's the shape of the lots, here's the number of the lots. That's a subdivision. That's not a development plan. Development plan implies development.
Okay, thank you. I have no further questions. Anybody else?
Mr. Chair?
Commissioner Reardon.
Just for clarification, what is the difference between a minor subdivision and a bulk land?
So you're asking me a general land use question. So just so we're clear that that's what you're asking me, because there's nothing in our statute, our ordinances, that distinguish between the two. So there could be no differences. There could be differences that you could apply based on a new ordinance. But currently, we don't have the term bulk ordinance, bulk division in any of our ordinances.
Okay, any further questions?
No.
All right, there's no further questions, then this concludes all testimony for the appeal, and the floor is now closed. The time. I have a question. Oh. Keep on forgetting the one.
I can process it. Yeah.
I have, somebody use the microphone.
Please.
Go ahead, Ms. Small.
I have three questions. First of all, I'm not sure that you had mentioned that Campbell had spent tens of millions of dollars.
I said that was testimony given by an appellant.
I know. And you said that was testimony given by an appellant. I believe what the appellant said was that Vidler had spent tens of millions of dollars. Okay. Campbell had spent tens of millions of dollars on hydrology, okay, and they were only spending 5% of all of Aquifer Science, you'd be in the $200 million range for Campbell's expense. And Campbell, like I said, only did 5%. Okay, I believe the person that said that intended to say Vidler if he didn't. Second thing, after Campbell begins to start selling these 5 lots, and we all seem to be aware that Campbell is going to need to sell lots, or is going to want to sell lots. I'm very concerned that when they're selling a lot, and I said this earlier in my testimony, that they are presenting all of the Campbell responsibilities to the purchaser of the lots. And my first question is, I gathered from what you were saying earlier that you believe that the purchasers of the Campbell lots will be under the 2019 ordinance. You're not saying that?
I did not say that.
Okay, so do we know when they start wanting to develop their property, are they going to, the Campbell property, are they going to develop it under the 1999 ordinances or the 2019? Okay.
I believe it's the 1999, but I will also indicate that the differences regarding subdivision development are very, very slight. So you're not gaining a lot by going to the 2019 ordinance.
No, but we may be gaining a lot by going to, Edgewood may be gaining a lot by going to the more updated ordinances than the 25-year-old ordinances in our demands that we can make on the developer.
I don't believe there's any significant demands that would be different.
Okay, that's in the record. I would like to believe that, but I am very suspicious of the Campbell entity. I dealt with them going back to 2009. The next and the last question I've got, when we put the conditions on the plat that I think is probably where we're headed, are we going to make sure that we don't just put the 1999 ordinance conditions on the plats, but that we also put the development agreement on the plat as well? There are things in the development agreement that Campbell are responsible for. There's a statement at the very beginning of the development agreement, and I did not bring it up here with me. Give me just a second.
So if you could just do the development agreement because it ties in the subdivision ordinance. So it'd be redundant to do both, but you could. I mean, that's up to, I'm not going to speculate what the commission may want to do.
I would be very uncomfortable if we didn't include the conditions in the development agreement, because the development agreement, section 2, applicability says that if the town approves, bear in mind this goes back to 2001, if the town approves the annexation and zoning contemplated by this agreement, the terms and conditions and other provisions of this agreement shall, to the extent allowed by law, apply to and be binding upon Campbell, including its heirs and/or assigns and the town.
And I think that's true whether it's on the plat or not, so it doesn't hurt, I don't think, to put it on the plat.
I worry that Campbell is going to be in such a hurry to sell lots, okay, that then they're not going to worry about stuff like this.
So misrepresentation is, yeah, I'm not.
Thank you.
Thank you, sir. And sorry about overlooking you there. I'm so used to everybody sitting up in front.
He was standing up, too.
Huh?
He was standing up.
All right, so any more questions then? Then we will go ahead and conclude the testimony, and the floor will be closed, and we got the time here as 7:53. The commission need time to think about what they want to do first?
Yes. Yes.
Okay.
Commissioner, if I could, I understood the rules to say that we were entitled to a closing.
Closing statements?
It's on the agenda.
Is it on the agenda?
There's no time.
I'm looking at the notice of the hearing, page 2, appellant rebuttal. 10 minutes for rebuttal. And traditionally, the appellant does get I'm not going to spend 10 minutes, but I do want to say a few things.
I don't think your microphone, I'm sorry, I just thought of it.
Is that on?
Yes.
Oh, there we go.
Yeah. Thank you.
Okay. Mr. Chair, I bring that up because the rules that I think we were following identified that there would be an appellant rebuttal allowed of 10 minutes.
Okay, well, I was, in my mind, I was just, all the questions that you all were asking was part of it, but go ahead. Well, for the record, we'll go ahead and reopen. All right, now go ahead.
Thank you, Mr. Chair.
First, thank you for a courteous and thorough and your patience in this hearing. A couple of matters I need to make for the record. I want to object on due process grounds. I feel like we were put behind the 8 ball by the record being delivered later than the self-imposed standard of 5 business days by the town, put us really behind on what we were prepared to argue and deal with. Also on due process grounds, I object to Mr. Hill's involvement as an advocate, and let me explain why. He is a trusted, longtime employee. He's a respected local resource. He's an employee of the town. And having him present the case is kind of like a bailiff, a court bailiff, presenting and arguing a case before his own judge. And we think that is, I think that creates an appearance of impropriety, and I just want to put that on the record. I understand we're at the end of this, but I just, from where we sit, he should, Mr. Hill, because of his position of an agent of the decision-making body, is not an appropriate person to present. And why the applicant has not been allowed to present is a question that I just don't know the answer to. A couple of points I'd like to make in closing. I think even Mr. Hill's testimony indicates that bulk land subdivision is an undefined category of land use application in the town of Edgewood. He agreed, though, that it is a bulk land subdivision, what's going on here. And so you're in a situation where you're being asked to approve something that's neither fish nor fowl, and you don't have guidelines for how to do that. From my perspective, arguing as an advocate, I think at this point in time, the commission, the town lacks authority to decide a bulk land subdivision plat because it is not defined. It's not, you don't have a process for how that's going to be decided. You don't have application requirements for a bulk land subdivision, and you don't have decision criteria, and you don't have limitations. So an ordinance, which even Mr. Hill agrees is not, the bulk land subdivision is not mentioned in either of the ordinances that we've been talking about. You need that in order to proceed and decide and limit and label on plats. Mr. Hill referred to the master plan in one of his answers, but that's not even in the record as far as we can tell. I'd like to briefly mention the vested rights matter also in closing. It seems to me that the vested rights issue has not been fairly considered. If you go to the record, pages 2692 and 2693, there's a legal memo from your then lawyer, and she writes, I'm reading from it here, I recommend you amend your current subdivision ordinance to allow a bulk subdivision process. I make this recommendation based on the law and the likelihood that this matter will ultimately be hotly contested, may be appealed, and so she's recommending that a bulk land, she recognized, your lawyer recognized that bulk land subdivision was a category of application that is not dealt with in your ordinances. And further down, she deals with vested rights and concludes that it's a tough case for vested rights. And I'd like to say on vested rights that it's really largely a factual determination, or there has to be a factual determination of what level of approval has been granted and how much, if anything, has been expended in reliance on that approval. And you've got cases out there that your then lawyer identified and discussed that talk about how one thing might work here, one thing might not work there. But in any case, the Planning and Zoning Commission did not even consider the aspect of vested rights, as far as I can tell. And I apologize that I did not catch that was in the record. I'm told that it's on page 2186 or some page like that, but it's actually a link that our side put in one of its papers. So the vested rights matter has not been resolved. To cut to the chase, the ask that I'm making on behalf of the group here is that the application be denied because the town at this time lacks a bulk land subdivision ordinance provision sufficient that the board does not have authority today to make a decision to approve or disapprove a bulk land subdivision, and then the board should proceed to establish a bulk land subdivision process where you set out what the term means, how it's going to proceed, what the decision standards are, and how you're going to protect the community by putting things on the plat, which is what Albuquerque at least has done, or putting them somewhere else that shows that the bulk land subdivision is something that's really prior to a preliminary plat and then a final plat. Thank you.
Mr. Chair, Commissioners, I think you understand Bernalillo County's position, so I'm not going to add anything else.
Okay. Mr. Mall?
I have no rebuttal.
Okay. All right, so they always say third time's the charm. So now we're concluded, and the floor is closed. And now the time is 8:01. I think you went a little over the 10 minutes, but that's okay. All right, Commissioners, you stated that you wanted some time to deliberate and think about this.
Yes. Yeah. So how do we go about that?
Well, this is a judicial hearing and quasi-judicial, and we're technically the judges.
Mr. Chair, could I make some comments then in reference to that?
Yes.
So I do believe that there were some procedural errors and missing documents and some other things that we should have allowed more time for them to look it over. And I think that that would be a starting point, at least for discussion. And how we get to the next step based upon that would, I'd like Mr. Rowe to assist with that.
So I think right now, can you hear me?
I hate those mics.
Thank you. So, Chair and Commissioner, I think you got, some options, sir. I think you need more time to think about this matter. You can, take it on the advisement, and then you can have, another regular meeting to, discuss this matter. Or you can, if you have some type of issue you need to resolve, or let the planning and zoning to decide if that's to clarify, you can remand it, or you can modify the terms of their decision, and then you can you can deny their application. So you got a lot of options, and then you can ask the planning and zoning reconsider some of the aspect that you've been identified. If that's the case, you can do that too. But if you need more time, I mean, you can think about it, and then you can take it on the advisement, and then you can have that on the next meeting. Or you can, I think you can defer this matter to until next regular meeting. Or I think you can think about some point to be made, or some type of the finding should be made by planning and zoning. You can remand back and then asking them to reconsider and then get back to you. And then, or finally, if you got some issue about the clarification or conditioning, you can ask for the parties to provide some type of the briefing within 30 days, and then so that town commission can entertain about the specific condition to be met for the purpose of each party, and then you can review them, and then you can deliver them at the next meeting whenever you receive that kind of briefing. So you got some options, sir. So I think it's totally up to you what you want to do. And then I ask you that you can think about that. And then if you got anything that you may think that something should be clarified and then need more information, you don't have that information in front of you, or that has not been answered by either party, I think that those should be clarified from the planning and zoning, and or in the later briefing schedule, sir.
Well, it was my intention to go ahead and let the commissioners rather think on their own or think out loud, and then if somebody wants to make a motion, we'll move on to that.
Mr. Chair,
Commissioner Murillo.
I'll make a motion. I move to deny the P&Z decision to approve Campbell Ranch application for a minor subdivision.
All right, the motion has been made to deny. And do we have a second?
I'm inclined to second that, but I'd like to ask another question if I might.
Yes, sir.
Declining the application, what is that going to do? And what are the appeal processes after that? Can you help us with
So if you deny it, that means that the application applied to the PNG and their decision was denied, meaning that they're, and then if that's the case, there's nothing to reconsider or remand, meaning that it is over from the town commission point of view. And I believe that the developer or someone, party who agreed by this decision, can file the appeal to the district court under Rule 74, 75 under civil procedure. And then town commission can be named as a defendant. And then we have to deal with this at the district court level, sir.
Does that answer your question?
Nah, sort of.
So are you still seconding, or?
Well,
That's,
I still would like some more discussion on it.
well, if you second, then we move into
Okay,
discussion.
let's, I'll second it.
Okay, it's been motioned and seconded to deny. We'll move on to the discussion. Commissioner Murillo, since you made the motion to deny, can you please state the reasons on why you would deny this?
So after reading the documents and listening to the hearing just now, so for me, it comes down just to a couple of things. First, let me pull that up. First, I feel like there was a failure of access to complete records. It sounds like we were missing the amendment, so reference numbers 3813 to 3815. That was missing, so we're missing 2 pages. So that makes me wonder what else we're missing. In regards to the factual components of it, so if we looked at Exhibit A1A, the Annexation and Development Agreement, Section 3(1)H, it does say that Campbell shall demonstrate a sufficient supply of potable domestic water for any proposed subdivision of the land at the time of application is made with the town for any preliminary plat approval and in accordance with applicable ordinances and policies of the town. So then I actually have a practical concern regarding the sufficient supply of water. It hasn't been demonstrated to me that there is sufficient water to do this. So I didn't see anything in the packet saying that there was plenty of water. I've only heard testimony and what's been provided to me today indicating that there is insufficient supply of water. And then finally, if I go to Ordinance 1999, Section 14C3, it states, shall present evidence that adequate water and so is available. So those are probably my top 4 reasons why I made this motion.
Okay. Commissioner Reardon?
Yeah, that was basically the same things that I had concerns with, too.
Okay.
And-
Now, I did know, the beginning of your statement there, Commissioner Murillo, almost sounded like that was more of a wanting to remand this back to P and Z to clean up a few areas, but then, okay, but you did get into some definite areas that will facilitate denial of this. My big thing here is, whenever since I heard about this vested right thing, I've been starting to read about it, and I've read some of the previous court cases. One was in Albuquerque, and the other one was out in Santa Fe County. Both cases dealing with vested rights, and because the vested rights were not properly there in a court of law, it ended up. The final court said that they did not have vested rights, and it was overturned. The 2 cases that I'm looking at right now, one is Joseph F. Miller as the plaintiff, and this was against to the Board of County Commissioners of Santa Fe County, and that was number 26.336, June 18, 2008. So I can't even pronounce the names. I'm not, yeah. How do you pronounce that?
Yeah, I got a really hard time to
Satori?
say that. Yeah.
Or Satori?
Yeah,
Satori, okay. Denied number 31216, August 6, 2008. Let's see if I still have the other one standing up, because like an idiot, I went and closed some stuff out, and I think I closed the other one out. Hang on. Oh, no, it is. I had it as a PDF. The other one that I was looking at was Andalusia Development Corp. Incorporated versus the City of Albuquerque. And on that one, that case was revolving around it is getting late. The impact fees, thank you. In New Mexico, once again, and I'll just get to the quick of it. Once again, that went to the courts because it was originally approved that they didn't have to do the vested rights, but went to the court. And the first court said, yeah, we are good. The Court of Appeals came back and overturned it. So with that in mind, I'm going through my head right now. Whatever we do right now, this is most likely going to go to a court. And there is already precedence in here referring to vested rights, and we have not heard evidence that there are vested rights there to be able to hold the 1999 ordinance in place as the guiding document. And that is the main reason for my objection to this. Mr.
Chair.
Naya.
Your objection to this would be,
Mike.
sorry, guys. Your objection to this would be is to send it back to P and Z or
Well,
vote on it?
the motion is to deny, so that's what we have to work on.
So if we denied it, then it automatically goes to district court?
It doesn't matter
Yeah.
if someone would have to appeal.
Whether it be them or the,
Right. Or if the other option would be, instead of taking it to district court, they can go ahead and resubmit and start the process all over again.
That's why I was asking.
Can't be.
Pardon me?
Can't be applied.
no. It has to go to
Can't?
court no matter what.
Oh, okay. Thank you for the clarification. That's why I'm not a lawyer. I'm an engineer.
Mr. Chairman,
It's, it's
can I-
closed, but nobody,
can I make a statement?
no, we are in the middle of the motion. Sir,
If you're trying
sir, we
to,
can't hear.
Please stop.
Please, sir, have your seat.
It's getting late. There's so many pros and cons on both sides that it's just mind-boggling. They bring up a very good point about the not having the documents, but it was on video. They bring up points about two different types of processes that we could also look at too. And then that's 3 options. The fourth one is we can always make a motion and put everything on the plot. But if we did that, it's still gonna go to court. So, what I'm hearing is, this thing's going to court no matter what. So if that's the case, then I'm inclined just to say, deny it. I don't like that, because I think we're supposed to be strong enough to make a decision.
Well, denying is kind of making a decision, isn't it?
I don't know. I think it's kicking the can down the road again. That's what I think.
Mr. Chair,
Commissioner Reardon.
my initial thought was in line with yours, to allow us some time to work this with our attorneys. I would love to hear what our attorney advice would be at this juncture. Can we ask that now? Or is that,
No, it's,
That's
that
not-
part is,
it's too late?
yeah, that door's closed.
Okay.
We can always do it in an executive session in the next meeting.
You know, Commissioner Anaya is right. I mean, no matter what, this is going to end up going to court. I mean, even if we remanded this back to P&Z, and it gets hashed out all over again, and 6 months down the road, we're sitting right here doing the same thing over again. No matter what we say, one side or the other is going to take this to court. So it is my opinion to stop kicking the can down the road and keep on doing the same thing over and over again, expecting a different result, and let it go on to the next point, you know, the next step of evolution. Any further comment? All right, then we will take this to a roll call vote.
His motion first.
Pardon me?
His motion first was to
deny.
To deny?
And it was seconded.
Okay.
So it's to accept.
No, it's denying the
Deny
Yes.
Okay, the roll call.
Roll call.
Commissioner Murillo.
Aye.
Commissioner Reardon.
Aye.
Commissioner Anaya.
Aye.
So it's to, we just want clarification for the record.
Are you
So we have a clear
Mr.
record.
Chair.
Denying the application.
So that means you are upholding the appeals.
Correct.
You're granting the appeals and denying the application.
Correct.
could you change could you clarify your motion to be very clear about that? So you're granting the appeal and denying the motion, instead of just
The
denying
application.
the application.
Mr. Chair.
Oh, I see where you're going on that, because they always want to have motions in the affirmative.
Well, there's an appeal, so you're either
Yeah.
approving the appeal or denying.
So, all right, I'm in a little bit of uncharted water since we've already started the voting on this. Can we
Modify.
We already got three.
Yeah, go ahead, sir. I think you can ask for the, oral motion to amend your motion, previous motion, to clarify that the deny, granting the appeal and then deny the application.
I need a parliamentarian that's better than I am, because my understanding is, once we started the voting, we can't change anything.
I believe that Robert's rule that sometimes that so let's try to make it very clear, sir. Why don't you vote? Go ahead and vote, and then you can amend it. That vote, if that's the case. I believe that that may be the better
That would
course of
probably
action.
that would be the cleaner way.
Yes, let's do that, sir.
All right, and I am also going to vote aye. So the motion carries. So let's go ahead and redo the motion to include approving the appeal.
Amend.
Yeah. It's approving the appeal, isn't it?
Granting.
Granting the appeal, okay. Like I said, I'm not a lawyer. Appeal,
Mr. Chair.
Commissioner Murillo.
I move to grant the appeal.
All right.
Whoa,
What?
wait a minute. Can we have the attorney make the motion for us?
No, we got to do it. Because he's not a commissioner. He can give the attorney can give the wording.
That's what I'm.
But
Mr. Chair.
Spell it out for us
So,
exactly
yeah,
the way.
maybe I can suggest the term, and then you can either adopt, modify, or change it, sir. So I think what I can recommend is that the motion to amend granting the appeal and denying application. So basically saying, in Commissioner Murillo, you can say, I move that the town commission grant appeal and then deny the minor subdivision application submitted by the Campbell Farming Corporation. And then I think those are the kind of a cleaner way to
Yeah.
say it.
you get all that.
Say it again.
So I move that town commission grant appeal and deny the minor subdivision application.
Okay, let's try it again. Mr. Chair.
Commissioner Murillo.
I move to amend my motion to the town commission to grant the appeal and deny the minor subdivision application.
Clerk, did you catch all that?
I sure did, yeah.
Oh, okay.
You
I
sure
second.
didn't?
I did.
I second
All
that.
right, second. Do we need any further discussion? All right. Will the clerk please take the roll call vote?
Yes. Commissioner Murillo.
Aye.
Commissioner Reardon.
Aye.
Commissioner Anaya.
Aye.
Commissioner Brennan.
Aye.
Motion carries.
All right, everybody, thank you for hanging in with us. I just want to go just to add, like I said, this is going to go to court, one way or the other, so nobody's done. So there's no time to celebrate yet. With the one thing you can celebrate, that it has actually moved from this step and now can move on to the next step. And I thank everybody's patience. And you all were very well behaved. I appreciate that very much.
No.
Not yet.
Mr. Chair,
Commissioner Murillo.
I move to adjourn.
Second.
It's been motioned and seconded to adjourn. All in favor of adjourning indicate by saying aye.
Aye.
Aye. Any opposed, say nay. We are adjourned, and the time is 8:24.
Thank you for doing